ParlView at parlview.ttparliament.org.
Deputy Speaker.
As we resume, I will recognize the honourable member for Laventille West, and you have 14 minutes of your initial speaking time. Proceed.
Mr. Deputy Speaker, just before we took the break, I was making the point that we secured a loan in order to ensure that this major developmental effort in regularizing and settling land for all of its economic and other implications be resolved. Fortunately for us, we have, as acquired over the years, a tremendous amount of skill and talent and experience in dealing with the business of land within the land registry, in the registrar's office, tremendous experience. The Attorney General complimented the existing registrar, and indeed that officer has been exerting best efforts, acting optimally, professionally, to assist in this developmental effort. We have her and the other officers, their accumulated skills and talents over the years. We have many experienced practitioners in the business of land law, and therefore we are not altogether coming from ground zero. What we are doing here is improving that which now exists, rationalizing it, making it fairer, making it more efficient, and therefore Trinidad and Tobago is on to a good thing. We've always made the point that nothing is remarkable about borrowing money. All governments since 1962, under the independence and the 62 constitutional arrangements, when we became independent, all governments have borrowed, some to a greater, some to a lesser extent, depending on the issue of revenues coming from the, I would say, the hydrocarbon sector and otherwise. Today, more borrowing is required because, of course, with revenue projected at 35 billion and expenditure projected at 50 billion, bearing in mind it came from the UNC 64 to 50, we now have a $15 billion gap in the national accounts, and we have to borrow more money. The important thing and the point we want to make here as I pass from this is that nothing is inherently wrong with borrowing. All governments do that. All governments must do that. But it is not going to be a case of borrowing to thief or borrowing to waste or borrowing to give away. It has to be, I accuse no one of nothing. It has to be, I accuse no one of nothing.
I would just prefer you use a different word, please, for the records.
Thank you very much. While indeed, Mr. Speaker, I defer, Mr. Deputy Speaker, I defer entirely to you on this, except to say that while English is the language of the Parliament, we are permitted a little colloquialism from time to time, and I just borrowed one. But once I used that colloquialism, T-I-E-F, I heard hums and noises from my colleagues on the other side. It is as if somebody, they say, throw me corn. I didn't call no foul. The point is, easy. I have nothing to worry about. I have nothing to worry about. And as I told us, I have nothing to worry about. So we borrow money for development purposes, and we are assured of that. And we borrowed from the IDB. When you borrow for the benefit of the citizens and my constituents in Laventille West, when you borrow money from the IDB, there are very stringent loan conditions that the government must observe.
Mr. Deputy,
Otherwise,
48-1.
You'll have to guide me, member for Ropuch West, on
48-1.
proceed.
that's for the help of my friend. The issue arose as by the member for Pointe-a-Pierre, how he implied, how and when will this project be funded? He asked that. And I'm responding to him to say, we secured $100 million loan for this project. We saw some time ago, just in passing, that in Canada, a single decision by the Supreme Court of Canada, where they ruled in that Supreme Court decision that no criminal matter should last more than 15 months coming through the court system. And if it went more than 15 months, there's a presumption that it was unconstitutional as against the rights of the accused. That was decided in the Canadian court. And what did the Canadian court do? They invested millions and millions of Canadian dollars to improve the criminal justice system to keep pace with the dictates of the court. We have Pratt & Morgan saying 5 years in murder cases, and we still have not kept pace with that. Most of the guys who are convicted for murder wind up having their sentences commuted to life imprisonment. So when we borrow $100 million to make this important issue secure, land, the settlement of title and land, for all of its economic and other implications, this is a good thing. And as I was saying before, I was disturbed by my friend. The public must understand that when you borrow money from the IDB, there are stringent conditions that the government must follow, otherwise you'll get no further drawdowns. And severe penalties. So when we borrow, that is a declaration we intend to use the money for the purposes intended. Another government borrowed about, they began to develop a major highway in this country and refused to take an IDB or other international lending authority loan to avoid the stringency of which I just spoke. And that gave rise to all manners of things, some of which has to do with land issues and the settlement of title, because one of the problems with the Point Fortin Highway was that there was lands to be acquired for the purposes of that highway, as the member for Oropuch West told us, and that was not resolved. They spent millions, hundreds of millions of dollars paying people, rent place for people, pay them for the land, rent for place for them, millions of dollars, hundreds of millions of dollars, and the matters are still unresolved as we speak today. If they had borrowed money from the IDB, as we have done in this, that would not have happened. But they did it out of budget, madness, governmental madness. So let me move on from that point. Let me move on from that point. Let me move on from that. The member for Pointe-a-Pierre told us about public education and the need for this. Every civilized society realizes, notwithstanding the old adage that ignorance of the law is no excuse, in today's reality, not even a judge knows all of the law. That is why you have lawyers on both sides to advise Millard what the law is, and then Millard applies his own techniques and his own understanding of it and comes to his decision. No lawyer, no judge knows all of the law. It's just impossible. Every day we pass laws here, there's no way a citizen could know all of it. So, public education is a critical aspect of lawmaking. That is why we have the live Parliament channel, so you can hear us. That's why we have a website and the Parliament's website. You could go there. That's why the laws of Trinidad and Tobago are all on the website of the Registrar General's Department. So it is a valid point. One of the rare valid points made by my friend from Point Fortin. He managed that one this morning. Not Point Fortin, Pointe-a-Pierre. I'm sorry, Pointe-a-Pierre. Mr. Speaker, let me humbly apologize with sincerity to the member for Point 14, who always makes good points. Always makes good points. I was thinking of my friend from Point Appear. It was an error which I withdraw with sincere apologies to the member for Point 14. To equate both members of parliament is a troubling thing even to me. Troubling. So let me proceed now that I've gotten that well out of the way. Yes. Public education, Mr. Deputy Speaker, is very critical in all of this. And to show you how critical this is, one of the pieces of legislation in 1981, it was the Landlord and Tenants Act. Landlord and Tenants Security of Tenure Act 1981, one of the pieces of legislation that was not proclaimed and that we are still trying to work through here today. That provided that if a person was in occupation of another person's land as a squatter, or you were in occupation, you were entitled to purchase that land. In fact, first, you enjoyed a 30-year statutory lease. That law provided that you would now enjoy a 30-year statutory lease, which expired in the year 2011. And another benefit you had from that law was that if you had, the landlord or the owner had to give you, the occupier, first preference for its purchase if he or she wanted to sell it. And thirdly, upon purchase, you were to pay only 50% of the going market rate at the time of purchase. Many people did not even recognize in 2011, I was a member of this House in the Senate, when that law had come to its expiry. This Parliament, or the then Parliament, the 10th, extended that to, I think, the end of that year by 6 months to give the citizens an opportunity to either re-register their statutory lease or opt out. And there are many people to this day who was not aware of the expiry in 2011, the extension that went for another 6 months, and now they do not enjoy the benefits of that legislation. So I accept that public education is critical, and certainly the Office of the Attorney General and the Office of the Registrar will be taking action under the loan agreement to publish the benefits of the matters that are now in front of us. Finally, on that point, Mr. Deputy Speaker, in respect of land transactions, for the most part, lawyers are used because deeds have to be done in a certain form. Registration under the RPO has to be done in a certain way, and therefore most persons, if not all, utilize the services of professionals, i.e. lawyers, to carry out this. So just to comfort my friend from Point 14, even if his point appears, even if, I'm so sorry again, stop making, I need your protection.
Again, members, I'd like to hear the discourse of the Honourable Member for Laventille West. So again, please let's listen in silence. Proceed.
Thank you very much. Even if, as I was saying, Mr. Deputy Speaker, as I seek to comfort my friend from Point Appear, even if the person or citizens are not aware of the benefits of the measures that are being debated in this or these bills, this package, then if they have to do a land transaction, there's a great chance or likelihood that they will utilize the services of a lawyer who would be able to guide them accordingly. In respect of the certificate of comfort that came to be known while my friends were in office between 1995 and 2001, and the member for Point Appear did raise this question. He even said this morning, Hansard will bear me out, deed of comfort, just to demonstrate that he too needs a little education. There's no such thing as a deed of comfort. It was called a certificate of comfort because it was not a deed. Quite different. And this certificate of comfort, as I understood it, was merely to give an assurance to the holder, who would have been in occupation of state lands, that the state will not intervene to disrupt your occupation, would not throw you off the land. And therefore, persons came to learn because they went around calling it deed of comfort. And persons thought they had a valuable document in hand other than a promise not to be thrown off. Of course, those persons were not thrown off before. So they realized painfully that they couldn't take it to the bank, if I may use a colloquial construction. It had no such value. And they are all back to square one. But they made song and dance over certificates of comfort. And it really was simply an assurance that the state, but in many cases the state could not do it. Because members on the other side will know, lawyers have gone to court, including the member for Siparia, and asserted people's rights once they were in occupation of lands. Thank you.
It has expired. You have an additional 15. You care to avail yourself? Proceed.
Most certainly. So that we know, if you are in occupation of private lands, you come onto private lands and you enjoy peaceable, open, unchallenged occupation for 16 years, you can then approach the court under the RPO legislation and you can get yourself an adverse possessory title. And in relation to the state, that was 30 years. Adverse possession, as my friend from Oropouche told us, has to do with gaining title to the disadvantage of the paper or the title owner, where, you, as I said, you enjoyed undisturbed and unperturbed occupation for the period. Mr. Deputy Speaker, Clause 11 of the measures in front of us seeks to make Section 16(1)(b) of the Land Adjudication Act 2000 consistent with existing laws by changing the period for adverse possession. I've just explained what that was and how it worked in relation to private and state lands. And here, this Clause 11 amends Section 16(1)(b), and it amends it from the period of 30 years to 16 years as provided for in the Real Property Limitation Act. So it's a matter of consistency with other aspects of the law. Clause 11 also requires the adjudication officer, his office being described and defined by the Attorney General, I don't have to detain myself or the House with that, to record title in the name of the state. So once this law gets moving, the adjudication officer records title in the name of the state, where a person who is without paper title or documentary title has been in possession of state lands for a period of 30 years. So if you're claiming that you have been in a possession of state lands for 30 years and would normally have gone to seek adverse possession against the state in the way I've described earlier, this amendment allows the adjudication officer to settle it in the name of the state, which is the paper owner, and then notwithstanding that possession has been open and peaceful. It also provides for the declaration by the adjudication officer that a person as owner of a parcel of land where that person is in possession or with a right to a parcel of land but does not have a documentary title or has not been in possession of state land for a period of 30 years. So the adjudication officer can resolve those issues, and we will know when we deal with the tribunal. If you have any challenges, it could be resolved in the tribunal, short of going to court, and with the expense and time that that implies. As well, Mr. Deputy Speaker, we are proposing here an amendment to Section 16. And this amendment, in in these measures, we are proposing a new section 16.2, which says, where an adjudication officer records title in the name of the state, as I described a while ago, under subsection 1C, he shall serve notice on the adverse possessor, indicating that the adverse possessor may approach the land tribunal to determine whether the adjudication officer has rights to a vesting order based on adverse possession. So once it is recorded in the name of the state, the adjudication officer now serves notice on the occupier of the land, the adverse possessor, and tells him that he or she can approach the tribunal to see whether it can earn from order of the tribunal a vesting order, so that the land will be vested in the possession or in the name of the adverse possessor. Or if that fails, it remains with the state. It also provides that the Commissioner of State Lands or other relevant authority, because it's not only the Commissioner of State Lands has authority for lands, state lands in this country, any other authority other than the Commissioner of State Lands, they having authority or the control of particular land, indicating that the land is in occupation by an adverse possessor. We are putting in a new section 16.3, which says an adverse possessor of state lands under section 1B or C may apply to the land tribunal on his own volition, I'm just adding those words, in the prescribed manner, seeking a vesting order so that the lands could be vested in him or her as adverse possessor. All as the Attorney General tells us, and I love this description of same, logical, common sense approaches to rationalize the whole land platform. And as we know, this against the background, when this legislation kicks in, the adjudication officer will settle all lands. Every single square inch of land will be noted and settled either in the name of the state or where the documents reveal in the title of the original or the existing owners. And if there are any discrepancies, we move on to a challenge in the tribunal and a resolution of same and compensation and all of the things, all of the oils that would grease the wheels of this major project.
Oil lubricate.
Yes, or lubricate. Yes, yes, yes. I know you would know that. Yes. So, Mr. Deputy Speaker, the measures, and I can continue reading them, but for want of time, I think I've said enough on that. And I only said it because the member for Oropouche West and the member for Pointe-à-Pierre raised these issues, and one found it necessary to address them. But everything that I'm going through here now has been already explained by the Attorney General, has been in part explained by my friend from St. Joseph. I have tackled some of the issues that they raised in particular, and more than that, Mr. Deputy Speaker, as you would know, it is all before every member on the other side for their reading pleasure. If only, to quote my friend from St. Joseph, they would take a little time away from their very... If they would only take a little time to read these measures in the spirit of goodwill and with an open mind and in the spirit of the law rather than in the spirit of trouble and mischief, if that is so, and where that is so, then we would all be better served. We are attempting as well to amend section 25, and I had made the point earlier, which says, and this amendment says, any person who, having been served with a notice or an order issued by an adjudication officer under section 4.6 and willfully neglects to attend in pursuance of such notice or order, or to produce any document which he is required to produce, or willfully neglects or refuses to answer upon oath, or otherwise any question which may be lawfully put to him by any or, without reasonable cause, willfully neglects or refuses to indicate his land or to assist in the demarcation of his land when required to do so by the demarcation officer, commits an offense and shall be liable on summary conviction, and the law goes on. This is the context in which I had raised the SIS matter. Because when that matter is settled, as it must be, by the adjudication officer when these measures come good, notices will be served by those who have barred it around. Whether it's SIS as a company, or whether it's some fellow who I heard my friend from Oropuchi is calling Mamu, or whether it is by some name with the initials KR.
55(1)B, again, he's being tedious repetition.
No, I'm analyzing.
Member, again, prior to lunch, you would have expounded on this same particular aspect of your debate, and I'll prefer that you desist from it. All right? I think we have said what needed to be said on the matter, and if you can move on.
I am most grateful. So I was really, I will move on, but I was really addressing the amendment to section 25 with greater specificity. But if those matters trouble my friends and they want to get on their legs more quickly to produce for this House rather jejune arguments, I will give way. I will give way. But this was a more substantive approach to the amendment in section 25. And therefore, I would be guided by your ruling. So, Mr. Deputy Speaker, I think the Attorney General explained in great detail the purport of this legislation today. I think the member for St. Joseph elucidated remarkably well. I think, having taken my legs, I have responded in adequate manner to the member for Oropuch West and my friend who seems, you know, a little bit fuzzy and fuzzled today, the member for Point a Pair. Yes? And having done so, the advantages of this legislation, particularly in conjunction with the others, and this is for the benefit of my colleagues on the other side. Once all of these matters are settled, then what you will have is indefeasible titles to land. In other words, you have titles that cannot be challenged. And if it is challenged, the challenges will fail because there would be a process gone through to settle title in the satisfaction of the adjudication officer. So you now have indefeasible titles, and this will ensure the protection of property rights. All the defects in title that now exist, there are some lands. A man approached me the other day. There's a defect in a title in a particular piece of land I had personal dealings with. That is about 40 years old, and it cannot be resolved. This matter, starting afresh, will resolve that. So all defects or uncertainties with respect to property titles and boundaries, which obtain under the present common law system, would be an issue of the past. Title and boundary disputes will be less frequent and less costly because the whole system would now have been completely rationalized. So when the Attorney General comes here today on behalf of the People's National Movement and the government that party sponsored in this House, it is indeed a very good and plausible thing. He deserves our commendation. We fixing TNT, not no bogus claim. The real McCoy fixing it, not with talk. Not renting high-end vehicles and getting money we can't explain. I'm talking about real fixing TNT. Real fixing. And that's what we have been doing with great dignity and aplomb since 2015. And we will continue as we march into the next election. The other benefit that the public must know is that you will have greater access to credit facilities as lending institutions could safely rely on the certificate of title to provide a clear record of ownership. It also is a great benefit that title to property can be established easily and with certainty as the land register will be conclusive evidence of title. It will be conclusive evidence of title. It will promote investment and the ease of doing business, and it will assist the government with planning and development as it relates to the usage of land. Mr. Deputy Speaker, with those things said, I would like to thank you.
I hearing you. I am hearing you. And I am not tolerating that in this chamber. I really do not want to tolerate those sort of comments in the chamber. Member for Princestown.
Thank you, Mr. Deputy Speaker, for the opportunity to be able to contribute to an act to amend the Land Adjudication Act. Mr. Deputy Speaker, the Honourable Member for Laventille West started off his presentation by saying to us that facts are a stubborn thing. But the Honourable Member stopped short of giving us the entire quotation by John Adams. You see, Mr. Deputy Speaker, it says facts are a stubborn thing, and whatever may be our wishes, our inclinations, or the dictates of our passion, they cannot alter the state of facts and evidence. Mr. Deputy Speaker, the member for Laventille West, in his contribution, gave us a typical song and dance. And it appears as though the honourable member has also fallen victim to his own stubbornness. Mr. Deputy Speaker, in the contribution of the member for San Fernando West, we were told about persons who encroach on 1 inch of land, on 1 foot of land. Mr. Deputy Speaker, the member for Laventille West, I believe it is well known and well publicized, is one of those who has a case in the public domain for encroaching on his neighbor's land.
Mr. 48.6, no such thing exists. The member he should be taken to the Privileges Committee. I have no matter before any court.
Okay. Member.
Twisted as usual.
Member for Princestown, right? Again, be careful on the road that you are going down. I want you to tie it in, right, with regards to whatever point you're going to make with regards to this particular bill. Okay? And remember, you have ownership for what is said.
Thank you, Mr. Deputy Speaker.
But on standing order, on standing order 48.6, the imputation of improper motives. May I have your ruling, please? Thank you, sir.
Again, member, you take ownership. You either withdraw or you tighten directly with regards to the particular bill. Okay? Fine.
Mr. Deputy Speaker, I withdraw the comment, but except to say that the honourable member, again, went on to introduce issues with respect to SIS and the granting of lands to SIS by the former People's Partnership Administration. Mr. Deputy Speaker, the honourable member for Laventille West totally misrepresented, again, in typical style. You see, Mr. Deputy Speaker, the true facts lies in the Hansard of the Parliament. When an explanation was given with respect to that SIS matter, and it is well known, Mr. Deputy Speaker, that the EMBDC had indicated in the year 2015, March 10th of 2015, that SIS Limited was not squatting on 35 acres of land, and indeed they were paying rent for those 35 acres of land. Mr. Deputy Speaker, the honourable member for St. Joseph, in his contribution, chastised the member for Pointe-à-Pied, indicating that the honourable member for Pointe-à-Pied had no moral authority to speak on issues of corruption as it relates to land activities and land matters in this country. You know, Mr. Deputy Speaker, I want to remind the member for St. Joseph of a well-known name in this country. Her name is Juliana Peña. When this administration, a People's National Movement administration, saw state lands being provided for the construction of a private church that today remains one of the most controversial issues in this country, Mr. Deputy Speaker. Yet, the honourable member for St. Joseph wants to speak on the issue of moral authority. Mr. Deputy Speaker, moving on, I want to indicate that we must fix the broken system to effect today's legislation. And Mr. Deputy Speaker, we have indicated on this side there are 2 particular areas in terms of the clauses of this bill that we are particularly concerned about. It deals with Clause 3, and it deals with, in substantive matters, Clause 11. Mr. Deputy Speaker, when you look at Clause 3, with respect to adjudication officer, and we see that the Director of Surveys is one of those offices listed under Clause 3, I want to spend some time, Mr. Deputy Speaker, dealing with the woes that are affecting the office of the Director of Surveys. Because, Mr. Deputy Speaker, that would be the operationalizing limb of this legislation. Mr. Deputy Speaker, as of March 13, 2018, the staffing of surveyors at the Land Surveyors Department stands at 15. A total complement would be 60 officers. Therefore, Mr. Deputy Speaker, you see a huge disparity in terms of competence of being able to carry out the additional role, job, and function that will be needed with respect to the Land Surveyors Department. Mr. Deputy Speaker, the complement is inadequate, as I've indicated, to carry out the workload. But how do we deal, Mr. Deputy Speaker, with respect to succession planning and recruitment? During the lunch, Mr. Deputy Speaker, I had a short conversation with the Honourable Member for San Fernando West. And Mr. Deputy Speaker, I don't mean to be adversarial in any way with respect to these particular issues that affect the Director of Surveys office, because most of those appointments has to do with the Public Service Commission. Mr. Deputy Speaker, in the past, the department's full complement, as I've indicated, would have been 60. During the People's Partnership term in office, there was an attempt to change the situation, and the PSC was prompted to start the process of hiring land surveyors. Mr. Deputy Speaker, over 4 years ago, the PSC would have invited applications and advertised for the positions and subsequently started the hiring. However, since the People's Partnership would have demitted office in 2015, no additional surveyors have been added to the complement of staff. Mr. Deputy Speaker, I'm imploring the Honourable Member for San Fernando West. I know that Her Excellency spoke a lot about shedding light and bringing light, and I'm hoping that the Member for San Fernando West and members of the government will be able to provide some light with respect to what advances they have made towards the Public Service Commission to have these positions regularized with a full complement. Mr. Deputy Speaker, when you look at the Office of Director of Surveys, you would see that for the past 4 years, there has been no substantive office holder. Someone has been acting in that position. And what has happened from then to now? Mr. Deputy Speaker, in that position of Director of Surveys, some interviews have been conducted, but again, no substantial appointment to that office. Again, I'm asking the Member for San Fernando West and others in the government to hasten in the process with respect to the bureaucracy at the Public Service Commission that is stymieing the progress that will affect the operationalizing limb of this legislation as it relates to the Land Adjudication Act Amendment of 2018. Mr. Deputy Speaker, with respect to the Land Adjudication Act of 2018 and the Office of the Director of Surveys, you would see that that office deals with sketches, data for plans, measurements, notes of land measurements to be used. It also houses plans and data that is imperative in carrying out the work that would be undergoing with respect to this particular piece of legislation. Mr. Deputy Speaker, a stone's throw away from this building where the Parliament is located, right here on Dock Road, is the Office of the Director of Surveys. The building is currently a sick building. It is a building that was used to house the old post office, Mr. Deputy Speaker. Mr. Deputy Speaker, when rain falls, I have been to the facility myself. When rain falls, the building is flooded. The electrical is not on the walls. It is not overhead. The electricals are run on the floor, exposed. Therefore, there are hazards there at that office, Mr. Deputy Speaker. Mr. Deputy Speaker, the employees, they are the total complement.
Speaker, Standing Order 48-1, please.
Again, Titan, right? I'm trying to understand the point you're making. So let's tighten with regards to the Director of Surveys Department and so on, with regards to the bill. So
Mr. Deputy Speaker, if you look at Clause 3, it speaks about the Director of Surveys Office. And therefore, that is the point that I'm making. So I'm not sure if the honourable member has read the bill, but
proceed.
But, Mr. Deputy Speaker, Clause 3 speaks directly to the Office of Director of Surveys. And therefore, as I'm saying, if we are looking at the implementation leg and the operationalizing limb, you will see that we need to pay particular attention and focus to these offices. Mr. Deputy Speaker, you would also know at the Land Survey Board facility on 110 to 112 Frederick Street, the board, and you might be surprised, Mr. Deputy Speaker, for the past 2 years, the board has not paid their rent. And therefore, right now, they're faced with eviction. And therefore, Mr. Deputy Speaker, we cannot be serious in passing legislation here today with respect to the land adjudication and giving power to the Director of Survey, where we are now empowering them and giving them the tools to do the job, Mr. Deputy Speaker. Mr. Deputy Speaker, Mr. Deputy Speaker, another area I would like to turn to would be with respect to the issue of the Institute of Land Surveyors as with respect to the Land Adjudication Act of 2018. Now, the Amendment Act. Mr. Deputy Speaker, we know that this is part of a package of legislation that will deal with the administration of land in Trinidad and Tobago. Mr. Deputy Speaker, I am advised by the Institute of Surveys incoming president that there has been no consultation on this package of legislation. Mr. Deputy Speaker, these are the stakeholders in the industry who will bring effect to this legislation, who it will affect, Mr. Deputy Speaker. Mr. Deputy Speaker, I want to turn to a paper entitled Land Adjudication, titling Family Lands, the Easy Way versus the Right Way, that was written by Dr. Sunil Lalu, who interestingly enough is the incoming president of the Institute of Land Surveyors. Mr. Deputy Speaker, if you allow me a few minutes to go through this paper, what it would show is that government has opted to go the easy way versus the right way with respect to land adjudication and the issues contained in this entire package of legislation. Mr. Deputy Speaker, the paper says that the government of Trinidad and Tobago proposes to embark on a nationwide systematic land adjudication process aimed at securing good title for all parcels and thus an accurate and all-inclusive land register. This initiative was motivated by baseline studies that suggested less than 35% of land holdings in a sampled study areas held state-recognized title. Mr. Deputy Speaker, the article goes on to say, and I quote, "The ambit of the reform was to eradicate informal tenure, squatting, and family land, and simultaneously create a complete land register. Whereas an adjudication process of this magnitude and nature is no simple feat, it is presented in this paper as the easy way, suggesting that it perhaps the most obvious, yet least informed solution to the informality problem." I want to repeat that, Mr. Deputy Speaker. Whereas an adjudication process of this magnitude and nature is no simple feat, it is presented in this paper as the easy way, suggesting that it is perhaps the most obvious, yet least informed solution to the informality problem. Mr. Deputy Speaker, this is not the UNC saying this, you know. This is not a member for Siparia saying this or the member for Princestown saying this. These are the stakeholders in the industry who are saying this, Mr. Deputy Speaker. And therefore it tells us, is it a cop-out that we are really taking the easy way out as opposed to the right way out? Mr. Deputy Speaker, the incoming president of the Institute of Land Surveys indicated to us what they believe would be the best way forward with respect to land adjudication in Trinidad and Tobago. And Mr. Deputy Speaker, the incoming president of the Institute of Land Surveys has indicated to us with respect to adjudication of lands in Trinidad and Tobago and the amendments that we seek to pass, that maybe we should have looked at the St. Lucia model. And that has worked effectively. And again, Mr. Deputy Speaker, when you look at the history of St. Lucia with respect to land adjudication, you will notice that similarly, while we would have gotten support, and we heard a lot about the IDB, and I will come to that IDB report of 2016, Mr. Deputy Speaker. Mr. Deputy Speaker, when you look at St. Lucia, the United States of America from 1980, 1990, up to today, has provided both technical and financial support to improve the land adjudication process in St. Lucia. And today, that process has yielded significant results, that so much so that several other jurisdictions that we shared our jurisprudence with is also similarly adopting that St. Lucia model. And therefore, in the context of this bill that we are presented with today, Mr. Deputy Speaker, I always say, you know, I wonder whether or not members opposite do their homework. But, Mr. Deputy Speaker, land law has always been one challenge in my legal studies that has presented a great significant challenge to me. But in the pursuit of preparing for this bill, Mr. Deputy Speaker, I must say that I learned quite a lot, especially in terms of where we were in the year 2000 when the initial act was passed, and where we want to go and where we want to be in 2018 and thereafter. Mr. Deputy Speaker, these are substantial amendments that are being proposed, especially when you look at Clause 11 of the bill. And I'll come to that, Mr. Deputy Speaker. Mr. Deputy Speaker, I want to give an idea of what the St. Lucia model provides with respect to land tenure issues, with respect to land adjudication matters, and so on, Mr. Deputy Speaker. You see, Mr. Deputy Speaker, the St. Lucia model would have told us of the history of St. Lucia with respect to land registration and the titling project. The Honorable Attorney General alluded to that in his contribution. But in St. Lucia, the land registration, titling, and tenure project was designed to produce three outputs. One, a survey of all lands outside the National Forest Reserve, which Clause 11 deals with as well with the Forest Reserve lands. Boundary demarcation of exercising, holdings, identification of landowners, and a record of these data. Two, a new land registry system based on this survey. Three, a land tenure code embodied in the new legislation to regulate and record private land transactions. It said in that report, Mr. Deputy Speaker, at the time the titling and registration project was being designed, a tenure individualization program was to be implemented to facilitate land transactions, including the conversion of family lands to individual ownerships. The St. Lucia Development Bank planned to offer 10-year mortgages at commercial rates of 11 to 13% for 80% of the holdings valued up to the US dollar. The mortgages would allow an heir family to buy out the other heir's share. The farmer's share in the family land being purchased would count towards a 20% down payment, and family shareholders would receive the value of their shares in cash and debentures. Due to a lack of funding and mounting cultural resistance, the government did not implement the tenure individualization program. So it tells you some of the challenges that it faces as well with respect to registration, but also with respect to land adjudication. Mr. Deputy Speaker, fast forward. In the year 2004, Mr. Deputy Speaker, we were advised that with respect to land adjudication in St. Lucia, that they were able to successfully manage to ensure that titles and registrations were completed with respect to 65% of the population with respect to land adjudication, land registry, and titles in St. Lucia, Mr. Deputy Speaker. Mr. Deputy Speaker, when you look at that compared to Trinidad and Tobago, particularly in Tobago, with this particular report, it will tell you that we are nowhere close to any of that. And Mr. Deputy Speaker, it has always been an argument of whether or not government is putting the cart before the horse, in that we are hoping that we pass this legislation. It will bring about the desired results and the data. And Mr. Deputy Speaker, I will deal with the data in the context of the Inter-American Development Bank loan that the member for Laventille West and the member for San Fernando West spoke about, Mr. Deputy Speaker. Mr. Deputy Speaker, if you would allow me, and I'm hoping that the member for San Fernando West and the member for Arucum Baloney would take a look at the Inter-American Development Bank, because no one in this debate has spoken about the report that was produced by the Inter-American Development Bank with respect to Latin America and the Caribbean, with particular focus on Tobago. And the title of this Inter-American Development Bank report of May 2016, where Trinidad and Tobago participated in that with respect to the Land Valuation Division, the LSA, and other departments that fall within this remit of dealing with land issues. No one spoke about what is contained in the Inter-American Development Bank report. And I heard the member for Laventille West say, well, the loan agreement provides for everything that we need to effect this piece of legislation. You know, the member for Pointe-a-Pitre and the member for Siparia. When the member for Siparia spoke, the member said, when you look through the budget documents, you see no allocations with respect to effecting this legislation through the arms of the state, Mr. Deputy Speaker. And Mr. Deputy Speaker, when you look at the loan agreement with respect to this particular project, it does not deal comprehensively in terms of the administration of ministries and departments of government. What it tells you is that they will assist with the technical cooperation and the actual implementation of the programs that are needed, but it does not provide that follow-up support. So therefore, really, we are placing the cart before the horse. But this is typical PNM style. This is typical PNM style, Mr. Deputy Speaker. Mr. Deputy Speaker, the report of the Inter-American Development Bank as it relates to land adjudication and land registry and titles in Trinidad and Tobago, Mr. Deputy Speaker, is entitled A Methodological Framework for Comparative Land Governance Research in Latin America and the Caribbean. Mr. Deputy Speaker, when you look at the contents of this report that was published in May of 2016, and I was able again to speak to the director of the Institute of Land Surveys, who confirmed that Trinidad and Tobago participated and gave some of the evidence that is contained in this report. It says, Mr. Deputy Speaker, that the paper is part of a broader initiative to support the improvement of urban land management and housing services throughout Latin America and the Caribbean. And it gives a case study of every country, but more so particularly looks at Trinidad and Tobago with an emphasis on Tobago. Mr. Deputy Speaker, it's almost as though the government is not aware that they just only take the money from the IDB, but they're not willing to take the technical advice. But you know, Mr. Deputy Speaker, if the members opposite will look at the technical advice, the IDB actually congratulated in most parts of People's Partnership Government for advancing a lot of the work that was needed with respect to land adjudication in Trinidad and Tobago. A member for Ruka Maloney, the IDB points out in this report, if you read these reports, you know, I remember when the member for Caroni Central spoke in the budget debate. The member for Ruka Maloney said, but when I came into office, there were reports on my desk, and I had to read 10 and 20 reports. Mr. Deputy Speaker, if the member for Ruka Maloney read the Inter-American Development Bank report as it relates to land adjudication.
I'm not on a standing order. Mr. Chairman.
She's on a standing order?
I'm not.
Oh, well, sit down.
You gave way.
Members,
No, you said, I thought it was a standing order. Please sit, madam, I'm not.
Members, both have seat. Member, did you give way?
No, I thought it was reading a standing order.
Okay. All right, well, he did not give way, so proceed.
Yes, Mr. Deputy
Okay,
Speaker.
silence.
Mr. Deputy Speaker, the Inter-American Development Bank report of May 2016, what did they have to say? And the member for Ruka Maloney must tell us whether or not she has read and internalized this report and what has been put in place with respect to land adjudication as it relates to the Ministry of Planning. And Mr. Deputy Speaker, contained in this report under Trinidad and Tobago, as I said, with particular emphasis with Tobago, one of the shortcomings identified by the Inter-American Development Bank is that when you look at the indices that informed this report under Trinidad and Tobago, dash, not applicable. And when you look at the reasons for not applicable, dash, it is because no data has been provided for 1 year with respect to land adjudication matters in Trinidad and Tobago. Mr. Deputy Speaker, further, it goes on to ask, and I will ask, and I have continuously asked in this Parliament, and I know the member for Caroni Central has spoken on several occasions, has raised this issue. What has become of the Central Statistical Institute that will inform these case studies put out by none other than the Inter-American Development Bank, who is providing the funding for the projects with respect to land adjudication and land registry in Trinidad and Tobago, Mr. Deputy Speaker. Mr. Deputy Speaker, if the honourable member is so inclined, I will have to probably furnish the honourable member, Faruqa Maloney, with a copy of the report, because it seems, again, Mr. Deputy Speaker, that we do not utilize what is available to us to advance legislation, but also to advance projects that will redound to the benefit of the people of Trinidad and Tobago. Mr. Deputy Speaker, I want to quote from the report. And the report says, under Trinidad and Tobago, the case study should describe recent precedent in executing compulsory takings for infrastructure investment and environmental management. A few examples should be included to illustrate the issues at play, how widespread are issues related to sufficiency of notice and consultation on allegations of mismanagement, such as those recently reported in the news. How do these concerns relate to specific issues of land information management policies or procedures? Item number 2 in the Inter-American Development Bank report of 2016 May says, in relation to the land information management systems investment, the investment made by the IDB, SALIS and CMIS, and to the operation of the registry and cadastry, the case study should assess the factors that affect sustainability. It should also provide a clear understanding of current policy directions in relation to horizontal overlap between the two registry systems. Mr. Deputy Speaker, identifying in the report, it says, 3, will the ongoing and proposed investments provide the quality and efficiency of access to information, needs for achieving regularization goals to inform disaster risk reduction plans for infrastructure-related public takings for managed land conversions and to address the situation of family lands over time, for each given an opinion and a belief explanation for the opinion. Mr. Deputy Speaker, the Inter-American Development Bank report that I'm referring to identified 3 other areas, and it said, beyond allowing or interoperatively or registry and cadastry, are there additional opportunities to integrate land information and create efficiency and greater reliability? Specify the current location or information, what it is used for, and what key steps should have to be taken to integrate the data. 5, provide brief background that will help explain why systematic land titling still has not been implemented at scale. How is it related to weaknesses in land information management? What other factors are important? Institutional complexity, lack of financial or human resources, lack of consistency. And you know what? What is contained in the 2016 report, Mr. Deputy Speaker, when it says lack of consistency? This is not the UNC saying this. This is not Separia saying this. This is not Oropuchi saying this. I want to share with you, Mr. Deputy Speaker, Inter-American Development Bank report in black and white. In the report that I hold in my hand, Mr. Deputy Speaker, I want you to hear this one, and I want Trinidad and Tobago to hear this one. This is what the Inter-American Development Bank report of 2016 says. It says, what other factors are important in implementation? And a question, is it lack of financial or human resources? Or is it lack of consistent political will? This is what is contained in the Inter-American Development Bank after 1 year of PNM governance, Mr. Deputy Speaker. So on one side, while they praise the People's Partnership and say things were happening, 1 year later they say, well, things just tiny, nothing is going on. And why is nothing going on? And in black and white it says here, maybe it is because they lack the political will. And Mr. Deputy Speaker, that is like everything else in Trinidad and Tobago, whether it is healthcare, whether it is national security, whether it is sports, Mr. Deputy Speaker. This is not the UNC saying this. On this occasion, this is the Inter-American Development Bank. Mr. Deputy Speaker, there are international organizations and institutions that will provide comprehensive information in whether or not they actually express support and confidence in the work that an administration is doing. Remember, Mr. Deputy Speaker, that the funding from this project is coming from who? The Inter-American Development Bank. The report is published by who? The Inter-American Development Bank. Mr. Deputy Speaker, there are a few questions that I would like to raise in the context of this Land Adjudication Amendment Bill 2018. But, Mr. Deputy Speaker, there are some areas, again, I would like to touch base with respect to this report before I get to those questions. And it says, Mr. Deputy Speaker, when you look at the indices in terms of performance indicators, and I heard the member for Laventille West, who always like to talk about people on this side having no shame. The member himself has no shame, Mr. Deputy Speaker. You see, Mr. Deputy Speaker, when the member talks about performance indicators as it relates to ease of doing business, we will tell you today what a Kamla Persad-Bissessar administration did with or without stockings. You see, Mr. Deputy Speaker, a Kamla Persad-Bissessar administration in 2014 brought Trinidad and Tobago to the point of being ranked at number 66.
Yes, remember your initial 30 minutes has expired. You have an additional 15.
Yes, sir.
Care to avail yourself?
Yes, sir.
Proceed.
Mr. Deputy Speaker, a Kamla Persad-Bissessar administration member of Siparia in 2014 brought the ease of doing business in Trinidad and Tobago, even under the area of land use, Mr. Deputy Speaker, to number 66. Mr. Deputy Speaker, I hope that the member for Laventille West will take ownership of the position that they have brought Trinidad and Tobago today, which is 104. Mr. Deputy Speaker, from 66 under People's Partnership Administration with respect to land and the effect that it has on the ease of doing business to 104. But all we heard from the member from St. Joseph and Laventille West, I know we are in the period of Lent. All we heard was how great thou art. But I want to remind members opposite that they tend to sing how great thou art at funerals. And rather than an election victory in 2020, we will be singing at your political graves. Mr. Deputy Speaker, I want to turn to the areas I said of the indices, and it speaks to the type of land administration system. The facts and figures and the notes indicate deeds and title registry operate in parallel. Registration is voluntary. Title registration introduced in 2005. From 2005, the document goes on to say that while some work has been done between 2010 to 2015, that they expected more should be happening at this point. It also deals with squatters and informality. It deals with tenure security, tenure types. Mr. Deputy Speaker, it talks about the role of local government, of other ministries. And again, Mr. Deputy Speaker, when you look at this Inter-American Development Bank report as it relates to land adjudication, it tells you that there's a disparity in terms of the work being done by several ministries. So what this report tells us is, apart from not having the political will, is that ministers do not speak to each other, because in several ministries, there's no cohesion and there's no single thread as it relates to land adjudication in Trinidad and Tobago. You know, Mr. Deputy Speaker, I will turn to the area of some of those questions that I would like to raise with respect to the Honorable Attorney General clarifying some of the issues for us, Mr. Deputy Speaker. Mr. Deputy Speaker, when we look at the area of Tobago, you will also see contained in the report that a lot of focus was placed on Tobago, but again, we have been short on information. Mr. Deputy Speaker, as we know, in Tobago, there's the oldest legally protected rainforest in the Western Hemisphere. But, Mr. Deputy Speaker, Clause 11 of the bill will tell us that there are some concerns with respect to Clause 11. And I would like, in the absence of the member for San Fernando West and the member for Port of Spain North, St. Anne's West, and maybe the member for Laventille West, Mr. Deputy Speaker, will be able to take note of some of the issues contained in some of the areas that we deal with respect to the Public Service Commission.
Members, silence.
Mr. Deputy
Laventille
Speaker.
West, silence. Go ahead, member.
Mr. Deputy Speaker, it says some of the questions that should be looked at is, how does government intend to work with the PSC to stop the bureaucracy, to deal with the Director of Surveys Office? Is government prepared to meet and consult with the Institute of Land Surveys in an attempt to stop not an attempt to stop the bill from passing, but to see how stakeholders can contribute to an efficient system. Mr. Deputy Speaker, we also need to see how whether government has considered the St. Lucia model. Mr. Deputy Speaker, we have to ask whether government has given thought to the implications of the gentrification of land, especially with respect to Tobago. Mr. Deputy Speaker, we have to ask the questions with respect to the forest reserves. When you look at Clause 11, it speaks about sensitive areas. Why would government want to remove this discretionary power from making declarations? What would now be the process? And I'm sure the member for San Fernando West will tell us that it is to come in the other bill. But, Mr. Deputy Speaker, what we are seeing is the bulldozing of institutions that protect the public interest. Mr. Deputy Speaker, we have to ask whether government has earmarked lands that falls within this Clause 11 for public or state use. How does government intend on dealing with displaced persons yet to receive compensation for the Claude Noel Highway as land adjudication matters has stymied this process? What is government's policy on squatters who have been on the environmentally sensitive areas for years? Are they going to relocate them? Mr. Deputy Speaker, who determines what are environmentally sensitive areas? And Mr. Deputy Speaker, you would have seen areas cropping up with respect to no man's land in Tobago, with the Aripo Savannah, now with the nurseries. Government has remained very silent on those issues, Madam Speaker. Madam Speaker, has government identified state lands that are being squatted on right now, whose occupiers have certificates of comfort, that they will be either transferred or removed to another location, Mr. Deputy Speaker? Mr. Deputy Speaker, this is really an open-ended debate, because the Honourable Attorney General is telling us it is very simple, and while we agree that several of the amendments are simple amendments, when you go and you drill down further into Clause 11, it raises the real people's issue, and they have always been anti-people in this country, Mr. Deputy Speaker. Mr. Deputy Speaker, I give the assurance here today that whenever called upon, the opposition will act responsibly. And therefore, we are acting in the interest of the people by not stymieing this process or saying we are not supporting, Mr. Deputy Speaker. It was never my intention to be adversarial in this debate, because I see the value that it can bring to the people of Trinidad and Tobago. But do not tell me, Mr. Deputy Speaker, you want to take away the rights and freedoms and liberties enshrined in our Constitution for the people of Trinidad and Tobago. They have given you a mandate to ensure that you look after their interests, the public interests. And all you are doing is looking after your own interests. Because the Inter-American Development Bank confirms what we know.
Standing Order 48-6. Good.
Kindly withdraw the statement with regards to looking after your own particular business and reword accordingly.
Sure, Mr. Deputy Speaker, I withdraw. I did not mean it in any disparaging way. But pretty much, Mr. Deputy Speaker, to make the fundamental point that is contained in this Inter-American Development Bank report as it relates to land adjudication in Trinidad and Tobago, that those on the inside and those on the outside of Trinidad and Tobago have seen, I know the member for Roodal East has spoken about his government with or without clothes. Today, Mr. Deputy Speaker, this Inter-American Development Bank exposes that this government is without any shame. And therefore, we as a responsible opposition will continue to raise the pertinent questions as it relates to land use, land adjudication, and land rights in this country, Mr. Deputy Speaker. And we will not be silenced on these issues, because these are important issues that must be addressed if you want our support. We are not saying that we are not supporting. What we are saying is deal with the real bread and butter issues that are affecting the people in this legislation, Mr. Deputy Speaker, and answer many of the unanswered questions that you have not provided with respect to information in the public domain. And the member for Laventille West and the member for Pointe-a-Pitre has spoken about the awareness and educating the population as it relates to this package of legislation. But, Mr. Deputy Speaker, as I wrap up, I really want to also take the opportunity to congratulate the member for Siparia for the continued work that she continues to do for squatters in this country. And we will continue to stand up if there's any continued attempt by this government to displace squatters. I know the Honorable Attorney General has given his assurance that while persons may make applications to the Land Tribunal and so on, which is to come, that they will not be displaced. We do not trust you because you have a history with respect to displacing people in this country, Mr. Deputy Speaker. Mr. Deputy Speaker, with those words, I thank you for the opportunity, and I encourage members to take a look at this Inter-American Development Bank report that will give you a clear idea of where we were, what the People's Partnership was doing, and clearly what you are not doing today. Thank you.
I recognize the member for Kumuto Manzilina.
Thank you. Thank you very much, Deputy Speaker, Mr. Deputy Speaker. You know, Mr. Deputy Speaker, this bill here before us, I have to really commend the People's Partnership under the astute leadership of Kamla Persad-Bissessar. That the very reports that my colleague for Princestown has indicated that many reports came, even during the administration of the PNM in the past. And, you know, one of the things that we did, Mr. Speaker, Deputy Speaker, is that we did not take these reports lightly. We took them very seriously. And, in fact, we inquired from the staff that would have been available to us, whether it's the PS and so forth, as to what they contained and how can we go forward with them. Because, you know, these reports come with, you know, the expertise. And so one of the things I would say that the Honorable Prime Minister at the time, Kamla Persad-Bissessar, did was she made a very bold and significant move, and that was to establish the Ministry of Land and Marine Resources. And the reason why the Honorable political leader did that at that time was because there was, as the AG indicated earlier, he says, how do we manage scarce assets? You know, and there's this unsettling of, you know, land being, you know, not being managed properly. And so the Honorable Prime Minister, Kamla Persad-Bissessar, saw the need for it to be separated. And being separated, it allowed the Minister of Food Production to manage agricultural state lands effectively, and for the Ministry of Land and Marine Resources to manage state lands effectively. And what in fact it allowed for a number of outstanding issues to be resolved in a very efficient and effective manner. You know, Mr. Speaker, you would not believe this, but when the Ministry of Land and Marine Resources was in fact established in very late of 2013, when we came into office, because I came in with a minister, there were files taller than myself. I mean, hundreds of files that were distributed throughout the building. And just out of curiosity, I just pulled a file. Did not know who it was, didn't know where, nothing at all, just pulled a file. And to my dismay, the file was older than I was. So old that I didn't even know if the people were alive, and I had no idea who this was. And a decision that was taken between the minister at the time, that was Jairam Simangal, and the PS, was that we had to find a way of bringing some sort of alleviation and end to this type of torture that persons were, in fact, waiting for titles or deeds to be transferred. And because of this, the minister and the PS sought to expand the office with experts, with persons who can be able to understand what the requirements were, and to begin the process of computerizing these documentations. And so as a result of it, Mr. Speaker, we are of the firm view that, you know, bringing this land adjudication amendment bill is very important, but there are things that are fundamental in it that we need to address. For instance, I mean, we have here in clause 4, I'm reading from the bill, so if I'm not waving it around. In clause 4, you have where you have the adjudicator officer should be an attorney with at least 10 years experience in conveyancing law, which there's nothing wrong with that, but should that be the only qualification for such an important position, especially a position that, allows the chief adjudication officer to record land as state land, then recording the absolute title and the recording of provisional title, where the adjudication officer is not satisfied that the person is entitled to be recorded with absolute title under paragraph B or D. And therefore, when you think of such powers like that, you want to be able to ensure that there must be more than 10 years experience. There must be some sort of credibility to the person's character and ability to be able to work effectively. Because, there's something that the member for Laventille West made, a statement he made. It was very, very concerning about it. And yes, it was very concerning. And the language that the member for Laventille West, made was regarding the Commissioner of State Lands. And it suggested that the adjudicator will replace the role of the commissioner, and it was something that they were actually looking forward to. And the most important one, the member is in fact confirming it. And what is also concerning is that right now, there is no commissioner of state land. As far as we're aware, there's no commissioner of state land, neither any of the senior officers who can in fact do anything at this moment. And it gives rise as to understand why is it there is no commissioner of state lands at this moment. Is there some link between a law enforcement officer and the state land commissioner, and that because the government is not pleased with what is happening, that they are attempting to sidetrack whatever it is, and this bill has been hurriedly brought to this House to bring in an adjudicating officer to fulfill whatever it is. And it's very, very frightening, because you see, at the end of the day, again, I come back to the report, the statement of the AG. People, it's unsettling. People are not comfortable with their issues of land, because land is a very serious thing. People kill for land, and as a result of it, you don't want to have a situation where persons are, don't feel comfortable that whatever systems in place or processes that are in place will not bring about a fair and a just system, because, fear could be relative, but you're looking for justice. People look for justice.
Let's exit the chamber with the device, please.
Offending device.
Thank you. Thank you, sir. And so, that is of concern for us on this side as to, the qualifications of the adjudicating officer, the chief adjudicating officer, and also what role will the adjudicating officer, is it that the adjudicating officer is going to override the Commissioner of State Land? Is there some sort of collaboration? What is it? The AG has not given an idea or indicated how the whole process will work. He did indicate that currently the process order right now is that you have the Minister of Agriculture, and then of course from the ministry, from that ministry, then it goes to the AG, and therefore you have a lot of convoluted processes in between. But Deputy Speaker, the reason why we established the Ministry of Land and Marine Resources was particularly for that, to separate it and to begin to allow the Minister of Agriculture to deal with agriculture and to put things in place to boost the agricultural sector, which is not happening at this time at all. As a matter of fact, the Minister of Agriculture doesn't even know what is happening in the Ministry of Agriculture. He is dealing with housing right now. And trying to justify citrus issues. So that is something that needs to be addressed very much at all. And then of course you have this one is very serious, the demarcation officers. Mr. Deputy Speaker, I am not telling you anything that I did not experience myself. When we were in government, there came a report. Someone wanted to, get their deed for their property. And this was going back again, this was going back in 1950-something. So the file was found and everything because people send letters of request. And when we requested the file, the Commissioner of State Land indicated, well, no, this cannot happen. The person cannot receive a deed because of the fact that this matter, the field officer, the demarcation officer, indicated on the file that the property was not being utilized for its intended use. And after repeated calls to the minister's office, I decided, Mr. Deputy Speaker, that I will go and do a site visit. Not that it was my responsibility. I didn't even know the person. And so, but the calls were so, it was insistent. And so having gone and having read the file, because I'm not leaving anywhere with any file, but having read the file, what was stated on the file was very different to what was in fact in place. And therefore, I took pictures and I sent it to the Commissioner. I said, Commissioner, you need to send your, probably other field officers and investigate this, because what is in this file is not correct. And therefore, I don't know what happened after that, but all I know is that there is a level of dishonesty that takes place in the various agencies, and we have to guard against things like that. So you put in, your senior demarcation officer has to, would bring the evidence of the markers and so forth. But I'm asking, how do we provide that the evidence that is brought for the boundaries are accurately identified? How can we guard against, corrupt activities taking place in the various agencies, in the various ministries? Because in fact, they do happen. And again, I'm going to bring a personal example of where, many years ago, my property was left to my mother, and she lost it. Why? Because it was changed inside of the Red House, and it showed that she was never the legal owner. So at that point, it was a choice that she had to take, whether either to go forward and fight it or to not bring a family dispute into place. She took the latter, but the point about it is that that level of corruption takes place where changes are made, where title deeds are concerned, and land issues and land registry, and there is nothing in place that this government has indicated to us that will deal with the corruption and the corrupt act that is taking place. But it comes down, at the end of the day, Mr. Deputy Speaker, how does this bill redound to the benefit of the ordinary citizens? The member for Pointe-a-Pierre, and I know it's Pointe-a-Pierre, it's my member for Pointe-a-Pierre made a remark, and he asked the AG, he said, I need you to break this down. And, the member for St. Joseph got up and was so upset and said, why is we don't think, and this is legalese, this is not legalese language, and anybody could understand it. And the reason why we ask, Mr. Deputy Speaker, is because we represent our constituents. In areas like myself, I have the one, according to the UN report, I have one of the poorest areas, all right? And as a result of it, it goes back to, many people, they own land, but it doesn't mean that they understand their rights to possessing this land. They know that they have it. And so at the end of the day, they come and they have to get legal advice as to how to go forward. I know some of these bills, I remember in a previous contribution, it was indicated that sometimes the bills are not even in the recorded as yet. And so a lot of lawyers are not privy and don't understand that there are new laws that have been passed. And as a result, there are a lot of issues that are taking place. Look, for instance, I was in a meeting on Sunday in my constituency, and the residents of Susu lands are up in arms because they have letters of agreement. Some have letters of agreement, and some have letters of conveyance. And as a result of it, they can't do anything because there's no deed. And then at the end of the day, we come here and we ask, how does this help the people in Susu lands, Kunaripo? There are people who have come to me too. They indicate they have the RPO. They can't get their deeds because there are issues with it. How does this bill, how does an adjudicator, how does a demarcation officer, how do these people redound to the benefit of my constituents concerning their land issues? And the answer is we don't know. We don't know. And so it's very concerning. And just to go back, we were very concerned that again, in our country, small. Trinidad and Tobago is not huge. We're small. And yet, when we went to the offices, you cannot tell how much land really is available. You cannot tell what is state land and what isn't state land, what is private lands. And so at the end of the day, what it is we did, we invested in doing one thing that I would commend member for Oropouche West. What did she speak about? We, under the People's Partnership, we initiated the aerial photography of land mapping. After 20 years, it was us. We did it. And therefore, as a result of it, we can be able to go back. This government can go and see that if there isn't anybody who was there prior to this time and between 1994, you cannot come and say that you own that land because there is facts, there's proof. And we invested heavily into the GIS system, which member for St. Joseph, thought that they had such a brilliant idea. We invested heavily into the GIS because of the fact we understood it has to be an ongoing process. And so therefore, for the government to be disingenuous in their comments, must be addressed. And so it is important for this government to indicate how are they going to give credence to putting this in place. One of the things that always concerns me, Mr. Deputy Speaker, is that we want to be able to say, the government wants to tell us that they're going to have this system in place where they're going to have everything computerized and so forth. Mr. Deputy Speaker, people have written in requesting different, whether it's for land titles to be transferred or whatever it is. And Mr. Deputy Speaker, citizens who submit information do not get a letter of acknowledgement. How can somebody prove that they have submitted a request to any ministry or any agency unless you have an acknowledgement saying your matter is being dealt with or your correspondence has been acknowledged, has been received? It is a mark of disrespect to the citizens. And so it is important for if the adjudicated officer is going to, in fact, be looking at what has been in place, what has been received, there must be some form of acknowledging somebody's letter stating that they have, in fact, received it so that when 10 years, 15 years, 20 years down the road, they can say, here is a letter stating that you have, in fact, received my request and it's still being processed. Whether it has been processed or not, I can't tell you because, as I said, I've been there, and there are files high up, taller than I, wider in a room that is big, with files, hundreds of files, some of them by far older than me. And so the member for, my member for Pointe-a-Pierre also made a comment. He asked the Attorney General, what is the time frame that is going to take for these things to be processed? And he says he does not know. So you have a process, you're going through a land deal at the moment. It has to stop because of some matter coming in, and it's indefinite. Right now it's indefinite, and people are unsettled and uneasy and angry. Why would we want to bring in a system like this that still is unsettling? There must be a method of putting things in place to bring about a more effective and manageable system. And to me, Mr. Deputy Speaker, the government has not reassured me that the process is going to be any easier. They haven't assured me that the process is going to be any more effective. They haven't assured me that they're going to even follow the reports that the Inter-American Bank has brought forward. So that is, again, very concerning to me. Then it's very troubling. And then, of course, the Attorney General spoke about Tobago. And my question is, I'm very concerned about Tobago because we were concerned about Tobago. We were addressing the grandfather's clause that was in Tobago because of the fact that Tobagonians are suffering. And so we were looking at how we can, in fact, look at it and bring about a system that would have been more suitable for the people of Tobago. But I'm asking, how will this proposed amendment impact upon Tobago with the government's intention to proceed with self-governance for Tobago? You know, is it going to make sense? Is it going to add? Is it going to take away? And so, you know, it's all well and good to just mention and stick in the name of Tobago, but what really are the plans, honestly and truthfully, if it is we're going to have self-governance, why are we going to impose our laws upon Tobago? You know? So it's a question that I'm asking the Honorable AG. And of course, you know, in the bill, I noticed there's a matter of asking for one map to be done. I was wondering why it is the AG would want to reduce the 2 maps to 1, in light of the fact that you have so many persons asking, you know, concerns about information being lost. There are many times that people come and they ask for information on their files, and their files are lost. And so why would you want to remove 2 maps and replace it with only 1 map? But just asking, understanding that our systems are not, in fact, functional and very safe. And let me put it as being very safe. We have so many agencies. You know, we have LSA that monitors state lands. We have EMBD. We have so many agencies. What is going to happen with the adjudicator? Is the adjudicator going to is the adjudicator going to function working with all these agencies? You know, we have the Ministry of Agriculture monitoring agricultural land. You know, so I think that the AG needs to expand a little bit on how the office is going to really function. And not just put, okay, we're going to have this officer in place, and we're going to have a name change for this person, and we're going to have demarcation officers. We need to know how it is they're going to function, and because people need to know out there. You know, and just to bring a item to point, you know, the member for Bhoendradatt Tewarie asked the AG, you know, would the 16 years and the 30 years be across the board in order for private lands as well as state? The member indicated yes. But then when member for Pointe-à-Pierre requested the information again, Mr. St. Joseph got up very angrily, and then, you know, member for St. Joseph. And then, of course, the AG indicated, he was shaking his head, no, it's not going to be the same. So therefore, you know, there's a discrepancy in the information, and we can't leave this parliament, we can't legislate laws, and there are discrepancies in what one thinks and what the actual law is. There must be a clear understanding across the board. So not just for us to understand, you know, because we are here debating. We're not debating here for ourselves, as Member for Princestown said. We're not here debating for ourselves. We're here to debate for the people of Trinidad and Tobago. And therefore, we must have clarity in here. The clarity cannot come after. It must come here. So that when we vote and we say, yes, we agree, and we are outside, the citizenry going to ask us, so what did you do? What does this mean? We can say with confidence, this will ensure that you get the deed that you have been waiting for 50 years ago. This will ensure that you will effectively go into any agency and be able to ask and request and get your information. But right now, I understand the land registry is down. I understand that there are no computers working. So if that is the case, yes, and so the point about it is why the people are very concerned, and therefore we have to ensure that it's effective.
Silence.
So I'm not going to be very long, Mr. Deputy Speaker. I just wanted to indicate that under the People's Partnership, we did have a very functional system. We had over 100 workers that, in fact, was computerizing, ensuring that the colony workers received their lands, ensuring that, that the deeds were properly prepared, and assisted in ways, Mr. Deputy Speaker, that would ensure effectiveness in the system. And of course, when the government came in, they just dismissed everyone. They cut off everything, removed everyone, and for what? And what has happened? When under the astute leadership of Camille Robinson-Regis, with the purpose of putting all these things in place was to make us better out there internationally, that when we invited foreign direct investors, that when they came into Trinidad and Tobago, they wouldn't have had this hassle. They would have been able to get to the registry, to get things done, and to be able to have the completion of business in a shorter frame of time. We had moved the ease of doing business from how many days, 60-something days, to 3 days. We had done that. We had done that, and we are proud of it. We brought it, and we had this tagline saying, from red tape to red carpet. That is what we did. But what this government has done, they did not. They just assumed, hey, it has people's partnership. We want nothing to do with that. And so let's remove it. And having removed it, now what has happened? You want to be able to, we went back to the dark ages. We are back in the dark ages. And so we are not opposed to this bill as the government thinks that we are. We are opposed to the process that will not ensure effectiveness, to the process that will not ensure that you have justice. People want justice. We don't want any systems in place that would allow for corruption to take place. The AG spoke about, and member for Pointe-à-Pierre, and also for Princestown, indicated that the sensitivity of lands. And I'm asking, will Aripo savannas be protected? Because that's in my area. And I don't want Aripo savannas, as well as a lot of people are very concerned that these environmentally protected, sensitive areas are being violated. And why? Why? We have St. Joseph in...
Excuse, honorable member, please. The outbursts across the floor, I really don't want it. Thank you. Proceed.
Thank you, Mr. Deputy Speaker. Yeah, they're protected. They are protected. You have in St. Joseph, we have an aquifer in St. Joseph that ought to be protected. All over the world, people are trying to protect their water. Are we? You just throw it away. And so it is important, Mr. Deputy Speaker, that we look at getting persons and getting our protected environment.
Silence.
And protecting our environmentally sensitive areas. It must not be that you have a law, but it's a law for one person, but that same law is being manipulated for another. And so, it doesn't bother me, Deputy Speaker. And so, at the end of the day, again, I'm saying we do not object to any good law. But the law must not be that there's an ulterior motive. And sometimes, from what I hear from the other side, I get the feeling there's some motives, and it's very concerning. And with those few words, Mr. Deputy Speaker, I do thank you.
I recognize the member for Roodal Moonilal.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, let me start off by indicating from the outset that with regard to the Aripo forest that the member for Camuto Manzanilla is talking about, the road that is intended does not pass through the forest. As a matter of fact, that information is totally incorrect and does not pass through the Aripo Reserve at all. Those on the other side have continuously tried to perpetuate misinformation. And Mr. Deputy Speaker, what is very concerning for us on this side is that those on the other side, when they were in government, we had a Minister of Planning and Development who wanted to put an entire sports complex on the Etihad ground, a complete aquifer, and they wanted to put it on top of the aquifer. And now they're coming to us to talk about passing through the Aripo Savannah, and it is totally incorrect. We had a Minister of Planning and Development who gave land to people in areas where they should not have been on that particular area for that kind of development. And Mr. Deputy Speaker, it is high time those on the other side stop spreading misinformation. Mr. Deputy Speaker, with specific regard to environmentally sensitive areas, this particular bill says in section 16.7, clause 16.7, that it would restrict an adjudication officer from making declarations on state lands which are either declared to be a protected area or a forest reserve, or to be an environmentally sensitive area, or where state lands have been identified by the state for public purpose. Mr. Deputy Speaker, why do they insist on misinforming the public of Trinidad and Tobago? It is totally unpatriotic, Mr. Deputy Speaker. And Mr. Deputy Speaker, let me say, with regard to the issues raised by the member for Princestown with regard to the IDB, Mr. Deputy Speaker, when this administration came into office, we were approached by the IDB for the main reason that nearly every single loan that had been negotiated or taken by the last administration had no form of implementation. We had to renegotiate nearly every single loan because the loans had been taken and the implementation had lapsed, and so we were paying commitment fees, paying millions of dollars in commitment fees with nothing being done. With a specific regard to the Registrar General's department, Mr. Deputy Speaker, that program, which had been negotiated years before, was languishing because no attention had been paid by the member for St. Augustine with regard to that program. There had been no GIS put in place. There had been very little done with regard to the flying over the area so that we could map the land in Trinidad and in Tobago. Today, we have a situation where the land in Tobago is being properly mapped. As a matter of fact, because of the concerns that we have with regard to the land in Tobago not being properly adjudicated, and there are so many people in Tobago who have issues with title to their lands. This government took the decision, which had not been taken by the last administration, to start the program in Tobago. They had done nothing with regard to ensuring that the land in Tobago was mapped or that the state land was properly registered. In addition to that, Mr. Deputy Speaker, when we were government between 2002 to 2008, we had been meeting with the Office of the Chief Justice, the Registrar General's Department, with the lawyers who were most involved in conveyancing, in an effort to ensure that all the issues relating to the lands in Tobago were dealt with. When they came into office, Mr. Deputy Speaker, and in particular, when they lost the election in Tobago, all of that came to a crashing halt because they did not care what happened to people with regard to making sure their land issues were dealt with in Tobago. May I also make the point that with specific regard to the IDB report that the member for Princestown spoke about, there is another report that says, and it's entitled A Methodological Framework for Comparative Land Governance Research in Latin America and the Caribbean. And it says, if I may be allowed to quote, land governance at a glance historically, the government of Trinidad and Tobago has taken bold measures to provide access to land for housing, including through private partnerships. Since as early as the 1980s, and that is under the PNM, the government has had programs that provide sites, financing, and site services. Sometimes, but not always, land rights were successfully regularized with title deeds within these programs. Major legislative reform efforts were undertaken in the 1970s, the 1980s, and the 1990s. At one point, a comprehensive package of land policy reforms was drafted, and there have been, over the years, a series of interventions by the government to ensure that land is properly available and titles to land are available to the people of Trinidad and Tobago. The Land Settlement Agency was created as a state corporation. It replaced the Settlement Regularization Unit with a better operational approach, including improved human resource practices and procurement practices. It was found that tenure security improved, decreased risk of eviction, and that in response, household investment in improvement to homes increased. And it noted that in 2012, there was no comprehensive land policy. 2012. Who was there in 2012? I wonder. And it also said that legal reforms needed to take place. So, Mr. Deputy Speaker, we cannot take the word of the member for Princestown. It also talks about the Land Tenants Act Security of Tenure Amendment Number 2 bill, which was in 2014. It said, the IDB said, that this would have clarified issues related to absentee land leaseholders and lease renewal. However, this bill lapsed. It lapsed under the last administration, Mr. Deputy Speaker.
Three times.
Mr. Deputy Speaker, the document goes on to indicate that there appeared to be no effort being made to ensure that land tenure in Trinidad and Tobago under the last administration was a priority. And Mr. Deputy Speaker, I can understand why it was not a priority. Because, Mr. Deputy Speaker, we can refer those on the other side to the Eden Gardens situation. And Mr. Deputy Speaker, if I may be allowed to just summarize what happened with that situation. And Mr. Deputy Speaker, the Joint Consultative Council for the Construction Industry, in a letter to the Registrar General dated 22nd July 2015, said, this report on the Eden Gardens complaint, this report is of two serious frauds in respect of Eden Gardens at Freeport. One, stamp duty fraud on the Board of Inland Revenue in respect of a transfer of valuable lands at a substantial undervalue of the order of 1/10 of the true value, and 2, overpayment for those lands by...
Deputy Speaker, 48-1. Trying to understand if this is a finance bill we are debating here or this is the bill that's... Trying to understand where is the leader of government business going with this.
Thank you very kindly. Mr. Deputy Speaker, I'll repeat. A letter dated 22nd July 2015 from the Joint Consultative Council for the Construction Industry to the Registrar General, and it says, "Dear Sirs, re Eden Gardens complaint. This report is of 2 serious frauds in respect of Eden Gardens at Freeport. 1, stamp duty fraud on the Board of Inland Revenue in respect of a transfer of valuable lands at a substantial undervalue of the order of 1/10 the true value. 2, overpayment for those lands by the Housing Development Corporation of the order of 5 times the maximum price the state could have lawfully paid. The HDC paid $175 million in November 2012 for this property, which could have been lawfully acquired for $35 million. And they are talking about corruption. And Mr. Deputy Speaker, the JCC went on to say, for your information, the JCC has also reported this matter to the Integrity Commission, the Director of Public Prosecution.
Silence.
Deputy Speaker, 48-1. What clause is the leader of government business?
Land. Clause under land.
Member, proceed.
Thank you.
I have ruled already on that matter.
For your information, the JCC has also reported this matter to the Integrity Commission, the Director of Public Prosecution, the Financial Intelligence Unit, the Trinidad and Tobago Police Service Fraud Squad, the Board of Inland Revenue, the Law Association of Trinidad and Tobago, and it is signed by Neil Dookie of the Association of Professional Engineers, Winston Doyle of the Institute of Surveyors, Mikey Joseph, the President of the Trinidad and Tobago Contractors Association, Alison Grossberg of the Trinidad and Tobago Institute of Architects, and Anthony Bridgewater of the Society of Planners. And Mr. Deputy Speaker, this bill before us today would assist the government in ensuring that frauds or alleged frauds on the people of Trinidad and Tobago and through the Registrar General's department would be avoided, even by the HDC, even by anybody who may have control over the HDC, as some had control over the HDC during the period 2010 to 2015, Mr. Deputy Speaker. That is the purpose of this bill. And Mr. Deputy Speaker, we are not unmindful of the fact that in many instances, those on the other side have perpetrated a fraud on the people of Trinidad and Tobago, particularly during the period 20...
Member, again, I'll ask you to be careful because you are identifying the word fraud with regards to the particular period, so kindly reword accordingly.
Thank you very kindly, Mr. Deputy Speaker. Mr. Deputy Speaker, it is clear that in many instances, despite those on the other side trying to give the impression that they care so deeply for the people of Trinidad and Tobago. They did so many things that indicate that this is totally erroneous, that we are left to wonder. Mr. Deputy Speaker, during the period 2010 to 2015, the contract or the loan document that was signed by with the IDB, specifically for strengthening of the information management at the Registrar General's Department, was signed on January 27th, 2014. By 2015, Mr. Deputy Speaker, only 13.53% of the work that should have been done had been done. In fact, the total amount disbursed was $2,706,399.95, with very little work done. And the fees paid by the government at the time were in the order of $315,007. At the time, it was to improve conditions for investment in Trinidad and Tobago by streamlining the property registration process. Mr. Deputy Speaker, over the time that those who are opposed to us sat in governance, there were innumerable challenges and nothing much was done. There was supposed to be the digitization of the land registry records, the automated land registry business solution, the vault remediation, and birth name insertion. Mr. Deputy Speaker, it is only in the time 2016 to now that anything substantial was done with regard to that IDB loan to deal with land issues. So, Mr. Deputy Speaker, when those on the other side try to give the impression that they care about the people of Trinidad and Tobago, we on this side stand to refute them on each occasion, because they did nothing with regard to the people except for those few people whom they had a special affinity for. Mr. Deputy Speaker, ours is the clear decision to ensure that we work in the interest of all the people of Trinidad and Tobago. We will do nothing of special interest for any group in this country. As a matter of fact, Mr. Deputy Speaker, I don't know if you may recall, in 1993, when we brought to this Parliament the bill to renew the Land Tenants and Ratepayers Association, which needed a special majority and had subsisted for many decades in Trinidad and Tobago, those on the other side would not give that special majority. And from that date to now, the people of Trinidad and Tobago have had to exist without that special protection. And Mr. Deputy Speaker, that is just a small indication of how those opposite to us think about the people of Trinidad and Tobago. They are the least of their concerns, Mr. Deputy Speaker. And Mr. Deputy Speaker, my intervention was to ensure that the record was set straight with regard to our relationship with the IDB. I repeat that we have had to restore the relationship of Trinidad and Tobago with the IDB that had been under severe threat under the last administration. And I would like to indicate that that relationship has in fact been restored and it has been strengthened. And may I also indicate that when the member for Princestown tried to mislead this House by saying that there were many reports on the desk of the Minister of Planning and Development relating to the IDB, in fact, what was on the desk of the Minister of Planning and Development when I became Minister of Planning and Development were concerns expressed by the IDB, and in addition to that, nearly 200 files from the Advisory Town Planning Panel where persons were not getting their matters adjudicated by the Minister of Planning and Development under the advice of the Advisory Town Planning Panel. Over 200 files. We have been able to clear that backlog, and now on a regular basis, the persons who need that kind of support are getting it from the Ministry of Planning and Development. Mr. Deputy Speaker, we will not be subjected to misinformation by those on the other side. And on every occasion that they try to rewrite history, we will continue to write the true history of Trinidad and Tobago, either now or what in the future we may have to do. And Mr. Deputy Speaker, I commend this bill to this House, and Mr. Deputy Speaker, we support the work that has been done by the Attorney General and Minister of Legal Affairs, and we will continue to give that support to the people of Trinidad and Tobago.
I recognize the member for Opuchis.
Thank you. Thank you very much, Mr. Deputy Speaker, and it's a pleasure to join this debate on one of several pieces of legislation that attempts to transform our management of land and the systems that we have long held and inherited in some cases. Mr. Deputy Speaker, I rise for a few minutes just to deal with a couple issues, 2 or 3, which I should not take all of the time to do. But, Mr. Deputy Speaker, may I first respond to the last speaker? And I'm extremely elated that the last speaker spoke at length about a bank, because I think the last speaker has good knowledge of the working of banks.
I wouldn't say good knowledge.
Well, have some experience and interaction with banks. And the IDB, you start already?
Again, member, once, currently central, I am making my remark. Member, again, don't know exactly where you're going, but once it's going down the line of any way that I notice, I'm going to stop you. Proceed.
Mr. Speaker, I assure you that you will not have any difficulty with me today, because I'm speaking about the knowledge of the bank, the IDB. And the last speaker is quite known in the national community, not only as the Minister of Planning today, but I think on a previous occasion under the former Prime Minister Manning, the member for Aroka Maloney also served as Minister of Planning and would have sufficient knowledge and ought to have knowledge of the working of the IDB, the bank, its rules, regulations, and procedure. I am not aware that the member has any other knowledge of the working of any other bank but that bank. And that is why I wanted to respond to that matter first. You see, Mr. Speaker, the IDB is involved, we are told, on this matter now, providing support, financial, technical, and other support on the transformation taking place. Mr. Speaker, I have not had the benefit of reading the loan arrangement with the IDB concerning this matter. I have not had sight of that. But there's an issue here that if the government is transparent and the government is open and the government tells us, so shares with the opposition the nature of that agreement, if the government shares with us the nature of that agreement, specifically what it is for, how it is to be disbursed, when, what are the conditionalities, we would not be in the parliament speculating or making statements where my colleagues opposite may want to accuse us of misleading. Because if we know, you know, and this is a problem that reared its head today, and it will always continue with this government. Once you don't have the openness, the transparency, the disclosure, it will lead to speculation. So the member for Aruka Maloney said today that the highway to Toko is not being built through the affected areas. You know, if you had taken the member of parliament for Komoto Manzanilla and other stakeholders on a tour of the route and explain all these things properly and prove that that is the case, we would not be speculating. If we are, because we're only hearing your side, we are not seeing, we are not getting any evidence. But there's this lack of disclosure. It is the same problem we face. The government is speaking in great terms about IDB loans for this matter, and the former administration didn't want to take IDB loan and so on. Are they taking an IDB loan for the Toko Highway? No. You are taking the money from the cash register. You are taking the money from the consolidated fund. Lavantil West, is there IDB loan to build the highway? No. But we praise the IDB and say the former government wanted to build highway to Point Fortin without IDB loan. Mr. Deputy Speaker, I must tell you, the member for Digo Martin West is in his earlier incarnation, also as a Minister of Planning, stood in this very parliament and spoke about the IDB and told the parliament that IDB loans carry conditions. They are bureaucratic. You cannot implement sometimes because of the bureaucracy, because of the time constraints. Today, there are converts to the IDB. But where was the IDB when you planned Toko Highway? You could have used the IDB to finance that because you claim you don't have the money that former administrations had. And I want to respond, Mr. Speaker, Deputy Speaker, as I must, because you see the member for Aruka Maloney, following the news of the week, got up today because the member for Digo Martin West is in the public domain telling the media that you all taking all kind of bacchanal, but you're not hearing when Moonilal talk about Eden Gardens this and Eden Gardens that. And Mr. Deputy Speaker, it is a matter of public record, which the member for Aruka Maloney raised the issue, but did not tell the country that Eden Gardens was investigated by the Integrity Commission. When a report was made, it was investigated for 2 years, and the Integrity Commission cleared that transaction and the former administration. And I must place on the record that I am one person that they approached because I held the portfolio of housing that included the HDC to give statement and provide records and so on. And the Integrity Commission, after 2 painful years, said that that transaction was above board. There was nothing we can find about it. But they come back with it because, you see, they think it's Reshmi Ramnarayan. So you just repeat it all the time and somebody will believe you. You know, so you come back with it. But the Integrity Commission dealt with that. Correct. And to hear today that you are going to report it again for the same commission, they were quoting, Mr. Deputy, from the JCC. It's very instructive. With all the information put on the record, it was from the JCC, Joint Consultative Commission or Committee or something, Council. They have raised that matter again. But the government today quotes from the JCC. This is the same JCC that accuses government of everything. But we quote today from them. So the Eden Gardens matter, and the member for Lavantil West, I think, had raised it earlier, of persons having value at 52 million and going for 170-something million and so on. There is the work of the Commissioner of Valuations in that matter. The government service is run through a Commissioner of Valuations in the Ministry of Finance. They do valuations for the government, not private valuators. It's the Commissioner of Valuations. And when we went to the Cabinet, we had a report from the Commissioner of Valuations, not a private valuator, and Cabinet took a decision accordingly. So let me put that to rest immediately, that if you have anything, if you want to raise for bacchanal value, for propaganda, Eden Gardens, go to the Integrity Commission, I think the 10 floors up, and collect a pile of documents on that, and it will do it. And when you go up there, I will advise my colleagues opposite, file your integrity declaration when you go up there. Mr. Deputy Speaker, I want to move on.
Member, retract that last statement, please. I think it have no jurisdiction in the
Mr.
debate.
Speaker, I will easily withdraw that last statement. So when you go up to file that, file it. Mr. Deputy Speaker.
Member.
I mean file the...
Member.
Okay,
let's retract and move on.
I retract and I'll move on. Mr. Deputy Speaker, there are two troubling issues here that have been raised, and I just want to go a little deeper with the issues, because I'm not sure previous speakers may have gone in a little depth with it. And I wanted the member for San Fernando West at some time to just explore something with us. The first issue is the IDB loan. Now, is the IDB giving this loan for this business a loan, transformation of land registry and management and systems? Or is it a loan for other things? One. Secondly, is it a loan to pay recurrent expenses? I don't think so. I'm not sure the IDB gives loan to pay staff, to pay for rental of buildings, to pay for supplies of office. I am not sure the IDB give a loan to pay for those things. In my knowledge of IDB, they give loans for technical support. They give loans for capital formation, investment into... I remember the IDB was involved with us in the Land Settlement Agency for squatter regularization and so on, and they provide loans for the technical work of that. Even I suspect for some grant funding as well. But the IDB will not provide a loan, to my knowledge, for recurrent expenditure. True. As the government has to find the money. And Mr. Deputy Speaker, I want to put on record that in the budget documents, there is no provision, none at all, for land tribunal, land adjudication officers, demarcation officers, adjudication, whatever. I am not sure in the government, in the provisions for this financial year, they have provided for that. If we are correct, then this will not start. The IDB is not going to pay for the salary and benefit and gratuity of people that way. You pay for it. And just point us, without attacking us necessarily, point us to the budget documents that provide for the payment for all of these matters that you want to introduce. And that to me is critical. The other matter, Mr. Deputy Speaker, when I spoke on a related bill, I had a point to make that time had gone. The year 2000 to 2018, 18 years. Our thinking in 2000 is not our thinking in 2018, clearly. We have a different approach, and it may be useful to relook. Although the 2000 legislation is the legislation of the United National Congress. But, Mr. Deputy Speaker, this is 2018. Those who might be around in 2038, and my friend from Couva North and so on, I don't know what they may be up to, but they could be there. But those who will be there in 2038, would they reflect on us in 2018 and say what we said was sacrosanct and this was a proper policy approach and we should implement in 2038? So we have to look back. Now, we are very concerned, and at the appropriate time, we may also advance an amendment to this amendment bill. To include, it may well be to include rather than to take off. Because you see, Mr. Deputy Speaker, in the Land Adjudication Act 2000, because we have to go to the parent bill to understand what we are doing in the amendment bill. It is section 4, I believe, in the Parent Act, and I have it in my hand, Mr. Deputy Speaker, where it says appointments and general powers of certain officers. And it is at 4.3, the President shall appoint such assistant adjudication officers, demarcation officers, recording officers, survey officers as may be necessary for the purposes of the Act. Now, unless I'm mistaken, this is not being amended. This is in force. The President appoints. We have all agreed that when we say President in this context, it is the Cabinet. The member for Diego Martin West, in his statement earlier, said that this has been happening from ever since. We have had this, all governments have had this situation and so on. And the member for Diego Martin West on this rare occasion was correct. But, Mr. Deputy Speaker, When the cabinet appoints, and I'll give an example, cabinet appoints someone as director of the SSA, deputy director. Cabinet appoints someone in different boards and so on. Those persons, their contract is subject to review by cabinet. You can go to cabinet and revoke an appointment. You can go to cabinet, when the contract expires, you may not necessarily renew. In fact, right now in an important office, in the process of transition, officers may not be renewed. They may not be renewed. So that, look at this, demarcation officer that has such power to go onto land, to demarcate, to engage citizens whose rights are threatened, or who has a claim that their rights are being violated. They have to meet and interface with those persons. They have to go before a judge. They go before the court to present a case. And the opposition, we are saying today that it cannot be that persons who are beholden to the cabinet for an appointment, and the cabinet cannot appoint indefinitely. Again, correct me if I am wrong. But I am not sure the cabinet could make an appointment to anyone indefinitely. But the cabinet itself is not indefinite. They cannot appoint anyone forever. It has to be on the basis of some term, 3 years or 5 years, as the case may be. I think in industrial court, judges are like that, unless I'm mistaken. Yes. They're appointed by cabinet for a particular period. And these are judges. But this is a cabinet appointment. So a demarcation officer comes into being because the cabinet approves for a particular time. That person knows that they are dependent on the cabinet, any cabinet, whether it's PNM, UNC, da-da-da. They are dependent. They have a job. They are in a position where they have no security of tenure. They have they have that feeling that at any time the cabinet can meet on a Thursday, as the case may be, and revoke their appointment. Or the cabinet can restructure something and they are out. The cabinet restructured something the other day. I think 3 people lost their job. So, Mr. Deputy Speaker, I am saying that in today's condition, where these people are going to conduct surveys and demarcation and such critical issue of land, they ought not to be dependent on the executive of Trinidad and Tobago. But they should be independent. They should enjoy security of tenure. Terms and conditions that are worked out with the CPO, but they should be protected by an independent institution. In the case, I believe, of the of other persons in this business, it is the Judicial and Legal Service Commission. I am saying that the opposition, we believe that the demarcation officers, we should look to put them under the Public Service Commission so that they are independent. At the Commissioner of State Lands, those officers there, notwithstanding their problems, I think somebody has been suspended and so on, but they are under the Public Service Commission. That's where they are. They cannot be removed like that. They do not have to take instructions from politicians, where if you do, well, you save your job. If you don't, you lose your job. And this is Trinidad and Tobago. People can understand what I'm saying. Important considerations like appointing demarcation officer. While it was in the 2000 Act, I agree, passed by UNC administration and the Parliament as a whole, we have to review that. Because you see, Mr. Deputy Speaker, you cannot have critical officers like this, dependent on cabinet to pass a note to hire them. It is a recipe, not that my friends opposite, I'm not casting aspersions on them at all, but it is a recipe for corruption and nepotism. The same corruption and nepotism they talk about today and want to highlight all over the place and so on. Mr. Deputy Speaker, that is a recipe for corruption and nepotism. That you hire people and you fire them through the cabinet. And the member for Laventille West repeats something that he says all the time. He says, well, there's a judicial review procedure and you can go on the grounds of illegality, unreasonable conduct, and so on. The unreasonableness principle, and if something is blatantly unfair. Incidentally, the judicial review legislation was passed by which administration? The United National Congress. Yeah. So it is the UNC that gave that right. Okay? But you see, the member misses a point. Not everybody is courthouse bound. When you're dealing with land matters, you're dealing in cases with poor people. People who themselves will not want to access court. So you have to wait for a matter. Then you have to decide, listen, I think my rights are violated. And you go to the court for that? No, in the case of some treatment. Because you rose and you said that the judicial review process is available. But Mr. Deputy Speaker, all I am saying, and I want to continue, I have some other points to make, is that we must not use the courthouse in any form as to suggest to people that that is their first port of call. We should prevent upfront issues of discrimination, issues of unfair treatment, issues where we can be prone to violating a right or perceived to violate a right. Don't be hurried to go to court, because not everybody could do that. Yes, we are going to set up a land tribunal. Huh? You don't have the money to do that in some cases. Yes, we're setting up a land tribunal. Yes, you can go to the land tribunal and so on. If you feel unhappy. But why do you want to do that? I mean, clearly we don't want to transfer the burden of the High Court as a burden to the land tribunal.
Remember, in Standing Order 51, anticipation, again,
sure.
Remember we have that bill still to discuss, sure. So again, try to desist.
Okay, so Mr. Deputy Speaker, the point I make is that we ought to be careful when we are making these appointments. And I don't want to bring in industrial relations matters into this business, but to say that that has been a complaint in the structure of the labor law in this country, because land law, labor law are both inheritance of British common law and British institutions. And one of the big complaints has been the structure and functioning of an industrial court where so-called, quote-unquote, judges, although they are members, are dependent on the executive. The very same thing can happen here, where key office holders in the structure of this land management and land management system, legal system, are beholden to the executive. And it is not something we should take lightly or just say, well, this happens all the time, it's always happening in this country. It cannot be that approach. As bad as they are, and as bad and as critical as we would like to be, there is still some value to an independent service commission. There is still some value to that. Mr. Deputy Speaker, one other matter I just want to touch, because again, colleagues opposite raised it. And when colleagues opposite come to the table, they come sometimes to accuse those of us on this side of allegations or wrongdoing and so on. And I don't mind that. We have been in government for 5 years. Some of us, like member for Caroni West, Caroni Central, have been in government for more than 5 years. So if there's something that you believe that was wrong or we did badly, nothing is wrong with raising it. That's what Parliament is for. But when you raise a matter of wrongdoing, I think you must be brave enough to come with the information, the statistics, the data, and particularly when you're in government. Because you see, Mr. Deputy Speaker, in opposition, we cannot command information. I cannot go anymore to the housing ministry and ask for data on something. If I go there, I can't. I mean, I'm lucky if I get a cup of tea if I go there. But I cannot get information and data as the Minister of Housing can. I cannot get information as the Attorney General can. But when you're in office, you have a duty when you make allegations or you make statements that you have the information, because it should be ready to you. And today we heard about SIS and so on, and that is a favorite mantra of colleagues opposite to here. In one case, we heard of 70 acres. So I asked my colleague, what are they talking about in this debate? Only to be told that it is not 70 acres, it is 35 acres somewhere, that the EMBDC rented lands that were doing nothing, serving no purpose, making no money for the taxpayer, not given away at all, were rented to a business.
Right now, remember, again, you would be about the fourth or the fifth person that is going down the SIS road. So again, listen, I'm making a statement. All right, so again, make your statement and tighten with regards to the debate.
Thank you, Mr. Speaker. So, Mr. Speaker, I just want to clarify for the record, I cannot leave the record like that the EMBDC would have rented lands to a business and to collect rent. I don't know whether it's a penny or $1 million or what, but as a principle, it is not a giveaway. Nobody gave away state lands. like that. And at least members of the government who can command information ought to bring information that is correct, that is accurate. Notwithstanding the clear, attempt that they make. I also wanted to ask for more information, because when you're in opposition, you ask for information. That's what we are here for. You see, the member from Aroka, Maloney, speaking about the loan arrangements with IDB and so on, said to the effect of that under our administration, 13% of the IDB monies were used, $2 million spent. And so that's 13%. That is what was said. But you know, this administration, they have been in office for 2.5 years. 2.5 years, coming up to 3 years. The member for Laventille West has had the pleasure to be in 3 ministries in 2.5 years. And we must ask, what have you done? If 13% of the loan arrangement expended under us, how much did you expend? And I want to guess nothing more than 13% have been spent, because you spent 2.5 years reviewing, analyzing, auditing, revising, and you have done nothing. So that, because it's very interesting, the minister said to us, 13% spent under the administration of the partnership, but didn't say how much spent under this administration halfway through. So they spent 50% of the time in office already and spent 0% of a loan. Because, Mr. Deputy Speaker, today you ought to tell us, Mr. Deputy Speaker, how much did you spend? Mr. Deputy Speaker, just to concretize a point I made earlier, because this IDB becomes a feature of this bill, because when we ask how you're going to do it, they say IDB. There was a debate, Mr. Deputy Speaker, Monday, May 21st, 2007. Incidentally, the debate was on the equal opportunities. It was on an equal opportunity bill. I just want to get clear, because you see, when I come to debate, I like to debate with my facts, with my statement. I don't debate talking out and pulling things from my hat and so on. Mr. Deputy Speaker, in that debate on the equal opportunity bill, the matter of the IDB came up. The member for Digo Martin West spoke, and I want to quote him, word for word. He says, our position in the PNM is that, look, the people of Trinidad and Tobago elected us to treat with their problems, and the bureaucratic position of the IADB bureaucrats is not what we were elected to endorse. Quote from 2007, we were elected to endorse and fix the housing shortage. If we could impact on that by borrowing IDB money and repaying as we see fit, that was no business of the IDB public servants. They, when they were there, had problems with IDB. Today they're telling us we should have used IDB. You know, this was their problem with the IDB. You see, Mr. Deputy Speaker, the Land Adjudication Act specifies the process by which we will deal with matters of conflict. And the matters of conflict will be matters over land dispute, property dispute, will be matters that deals with citizens and their grievances, and will be matters that deal, Mr. Deputy Speaker, with parcels of land, assuming that they are surveyed properly and so on. And all persons, I want to make the point, this bill, when you pass a bill like this, unlike, you know, some other type of bill, Customs Act and so on, which read by customs officers and so on, this bill impacts upon everybody. As a speaker a few days ago said, citizens high and citizens low. This impacts upon citizens high, citizens low. Mr. Deputy Speaker, it was shocking that all of us will face land-related problems, so that ministers of government, members of parliament, could face disputes involving land and property. And we, those of us in the chamber, may have to go to land, may have to get the help of demarcation officers. We'll have to call adjudication officers. You know, there are members of government, I believe, who are also facing property-related problems in courts and so on. And they will have problems with adjudication, demarcation, and clarity. They face that themselves. And some will face that. So that when you make a law, it is not only for landlords, as you call them, or land developers and so on. It is for poor, innocent people but it also could be for yourself. It could be for yourself. And if there are those on the other side who don't understand that, at least the member for Point Fortin should understand that these things can happen to you, and you could be called upon in court to explain yourself and whatever you have been doing over the few years and what you have not been doing with these transactions. Mr. Deputy Speaker, the qualifications of person is also a source of bother to us. Qualifications. And we would like, and I want to make the point because you see those on the opposite don't understand us. Huh? When we stand up and we speak critically, they believe critical mean we don't support. Yeah. They believe critical mean you don't support. We were critical of Factor, we support it. We were critical of Gang Bill, we support it. We were critical of children, something, we support. We support. But critical does not mean no support. So you ought not to go into your shell. You ought not to go into your shell and use your default position for abuse. You know, to use colloquial terms, you don't have to buff up nobody. You could get support. You don't have to buff up anybody. We're making critical points. And we are making points that you yourself may become the victims if you do not listen to what we are saying. You can become the victims. And one member is a victim, I understand, in another jurisdiction already. If the thing was done properly, maybe he would not have been. You see, Mr. Deputy Speaker, do not take lightly these allegations people make of fraud, of wrongdoing, and so on. It will come back to haunt members of the government if they do not get it right. One day you could stand in a public place and say, I am the victim of political discrimination, of victimization. When you make law, you do not make law for your neighbor. You make law for yourself first, to protect yourself.
Your initial 30 minutes has expired. You have an additional 15. You care to avail yourself?
After the break, of course.
Proceed.
Well, Mr. Deputy Speaker, I'm sure are you taking the break now? No, 5. Oh, 5, okay. Mr. Deputy Speaker, this matter came to the fore as a result of work done by speakers, by administrations before. So, in a way, this is not any one administration necessarily can take ownership. This is a strange bill in a way that all sides can take ownership and claim. The Attorney General has spoken about amendments he has brought and so on. And sure, we look at it, but it's building on a package that was presented before by the Partnership Administration. We have some concerns, but Mr. Deputy Speaker, in all fairness, I know that the member for Diego Martin Central, the member for Couva North, and I think a couple others would have to explain a few things. And I prefer not to get into some other materials that I would have done, but to give way to other colleagues. Mr. Speaker, I thank you.
I recognize the member for Caroni Central.
Thank you very much. Thank you very, very much, Mr. Deputy Speaker. And I take the opportunity to read from an IDB document entitled A Methodological Framework for Comparative Land Governance Research in Latin America and the Caribbean. The authors are Jolene Sanjak and Michael G. Donovan, and it was published in May 2016. And I read from that the following lines on page 18. The main land governance needs are overall policy coherence and performance at the end, the performance of the land registration and cadastral information systems according to Griffith Charles in 2011, improving the land registration system, etc., can be achieved relatively easily, low technical difficulty, and low political friction. So that although it talks or speaks to the issue of land coherence, this was before the strategy, national spatial strategy was laid in Parliament, in this Parliament, in the year 2013. And it, in fact, quotes on page 19 from that document. Planning for efficient and effective use. This is May 2016. Yes. Planning for efficient and effective use and management. Here the IDB is quoting. Planning for efficient and effective use and management of Trinidad and Tobago's land and ocean space requires many demographic and related factors to be taken into account, including population size and spatial distribution, demand for housing, employment, and goods and services, people's daily commuting patterns, settlement patterns, that is, people moving from one place to another, losing population and others, some places losing population, others gaining, and impacts on the economy, the environment, and the social structure of the country, and squatting and its implications for sustainable development. And the quotation that the IDB makes here is from the National Spatial Development Strategy of Trinidad and Tobago in the chapter Surveying the Scene, page 5, okay? The IDB then goes on, again on page 19, to say, regularization of squatter settlements is an ongoing priority in line with the desire to broaden its economic base for development. Trinidad and Tobago is now focusing beyond its primary city. This is to say the issue of squatter regularization nationwide. And you would remember, Mr. Deputy Speaker, that on the last occasion on which I spoke here last week, Friday, I said a critical element of the policy that we were advocating is the distribution and development of land, the distribution and the development of housing, facilitation of housing, and the notion of widespread share ownership by employees beyond income. It goes on to say, the Sustainable Development Manifesto of 2010, that is our manifesto of 2010, the People's Partnership, which became government policy for the first year, 2010 to 11, and which then was converted and absorbed in the medium-term policy of 2011-2014. So it says here, the Sustainable Development Manifesto of 2010 and the medium-term policy framework 2011-2014 set an agenda for development of regions and for sustainability. Historically, growth and population have been concentrated in both Trinidad and Tobago, but settlement patterns are changing with growth in other regions. The issues identified in these policy documents, that's the manifesto and the 2011 to 14 medium framework, include addressing the problems of informal settlements and broadening access to housing. So it goes on with that, and then it speaks to the things that need to be done in governance and the issues that need to be addressed. And it identifies what are some of the problem issues in the country. And I won't dwell on it or read it, but it says, for instance, the lack of the integration of the various sources of information. That is why the MIS, the GIS system and the information mapping system was so critical, the integration of all of these. It's not that the country did not have it. but they were in separate places and existed in silos, and they were not connected, and they needed to be harnessed. Then they estimated, this is a UN estimation, that 1/6 of the population was a squatting population in Trinidad and Tobago. That tenure security existed only in reality for about 50% of the people in the country that own land, and that does not have to do with squatters. And then they talked about these tenure types in the country, and they basically talked about the problem of family disputes and the settling of land problems and the settling of ownership of lands and things like that. So I want to say to the honorable member for Arouca Maloney, it is not reasonable to claim that, you know, we were doing nothing in government for the 5 years, 2010 to 2015. And it is not reasonable to claim that we were not doing it well. You may criticize it, no problem. You may say that you have a different view. You may say that the way we were doing it was not the way that you would do it. That's fine. But you can't come and say here that we were doing nothing and that we were not doing it well. The IDB also mentions in there, I don't want to take the time to read it, that because of the fact that we did the procurement bill, I think it's on page 20 in the same document, which would address the issue of corruption, and because of the fact that we had completed the planning and facilitation bill, which is law in this country, not fully proclaimed yet, that the country was on the right track in terms of taking command of the deficiencies in the land mapping, land ownership, land registration, basically getting the facts, so to speak, in one place, having to do with land in Trinidad and Tobago. So we were on the way. And the member from Arouca Maloney mentioned as she closed that, you know, she had to repair the business of Trinidad and Tobago with the IDB when she came in office. Let me tell you something. I had the president of the IDB, Mr. Moreno, come to Trinidad and Tobago on several occasions. I took him in East Port of Spain with the mayor of Port of Spain at this time, Louis Leasing. Yes. He was involved in Trinidad and Tobago business, and we had good relations with the representative here. We got the largest ever loan in the Western Hemisphere, $536 million US for sewage solutions in Malabar and San Fernando, which is part of something that is going on now. So all I am saying, I don't know what they're fixing, just fix this sewer.
Silence.
All I am saying to the minister is, look, we were there in government. The IDB is a multilateral institution. They are a multilateral institution focused on development financing. That is what they do. They do it all over Latin America, and they are funded by governments all over the world who contribute. China is now a major player in the IDB, although they are not from this hemisphere, because they have big Latin American interests. Japan is now a player in that, not just the governments of US and Canada and our own selves, because we contribute to the IDB to be there. The IDB is an institution that helps and supports developing countries and helps and support development projects. So does the CDB, so does CAF, so does other institutions. Just take advantage of what has happened before, build on it, build your relationship, look at the interests of the country, and let's keep the development trajectory going forward. There is no need to quarrel about this. I am not going to quarrel about this.
Oh, blame.
You know, it's not necessary. We have one little country here, you know, a few thousand square miles. We have 1.4 million people living in Trinidad and Tobago. We have the profile of the age of this country, and we have a future to create, and we have a bad present, and we have what looks like a receding future given the economic and financial statistics from the central bank here, which they published earlier this month. So I would say let us try and move the country forward, which is what we are trying to do and trying to contribute here to speak on this law. The Aripo Reserve, it is not the opposition that made a fuss about the Aripo Reserve alone because we are in opposition politics, you know. I think they had their biggest problem with fishermen at the sea. And I did not say, or anybody on this side did not say that we were violating the conservation. Sorry, what? No, I think, yes, Deputy Speaker. If I remember, she was saying that there was no consultation or that people were not involved in the process. But this fisherman of the sea said that. And the member for Uropuchis, when he spoke, he talked about the issue of transparency. He said, you know, if you did things in the open, nobody would, you know. So, but I think I heard the members from the fishermen of the sea make the case that when they drew the various lines, I remember reading this, to show the line of demarcation for the road, it was way within the reserve compared to where it should be. Now, I do not know if that is true, if it is not true. I imagine courts will deal with that. But if that is true, or if they have a legitimate case, eventually the truth is going to come out. The member talked about the, I don't know why she would do that. She talked about the sports complex in Etihad ground. That was a tennis facility that was pushed forward by the Ministry of Sport. The matter made it to the court of Trinidad and Tobago. The people were opposed to it because they said it violated the fact that it was a savanna and so on. The whole thing was going on when it finished, Bill. They basically objected at that point. I don't know if it was politically motivated or not. I do not blame the population. The population has a right to express its view on any matter that it wants at any point in time about anything. So I do not blame that. But what I do know is that there's a process. The Ministry of Sport is the person, the institution building it. The Ministry of Planning is the one that gives permission. The consultation process, which is what the issue was about, the consultation process was to have been initiated by the Ministry of Sport. But we got the rap for it in the Ministry of Planning. I didn't quarrel, I didn't argue with my colleague who was Minister of Sport or anything like that. We take the rap and we proceed. Okay, let the courts decide, let the people have their way, let the consultation proceed. I don't have a problem with that. What I do know is that I did not do anything wrong. And I did not violate any environmental principle. And I did not make any planning decision that was wrong. That was done by technical people in the ministry. She talked about other things. She's talked about giving land in places which should not have been.
Member,
Member for Roodal Maloney. Sorry, I do not mean to disparage in any way. The member for and Minister for Planning said that I gave land in places which should not have been. I want to say, to the whole population and to this parliament. I never gave any land to anybody for anything. And I want to say that there is not a piece of land that I own in Trinidad, because I have no land in Tobago. There's not a piece of land that I own in Trinidad that was not either inherited or paid for with money that I earned from honest effort.
No land.
So,
No land.
I won't get into the Tobago things. Stay out where. I wouldn't get into Tobago things, not because I don't want to get into those issues, but because I think other speakers have spoken to the Tobago issue on our side and showed that we were in the process, really, of addressing the issue of land registration and land tenure and distributing land titles in Tobago. This bill is in part about ecological and environmental conservation, because within the bill, you have powers to deal with that. And I want to say that this is a very important power, and how that power is exercised is important. This bill is also about squatters on state lands, Mr. Deputy Speaker, and it demands, because of the bill, a rational approach to land tenure, whether it is agriculture or in housing. This bill is also about private lands, whether it is squatters on private lands, whether it is tenants on private lands, the property rights of the owner that was raised by the member for Pointe-à-Pierre, and of course, squatters on state lands I already mentioned. So really, in a way, the bill affects every citizen who either has title of ownership, who claims title of ownership, who wants to own, or who wants to make a claim to ownership. It is a bill that affects every citizen in the country. And I think we know that not only that land is important, as the Attorney General said, and as other issues, as other speakers, both on the government side and on the opposition benches, said that land is a very important issue, it's a very emotional issue, and so on. I think that what it really tells us is that this business of land not just being precious and being important for emotions and for ownership and so on, it is also a question that issue that we have to be careful about. And I want to take two issues that have to do with ordinary people and use them as examples here. Because when the member for Aruka Maloney was speaking, she said that, you know, we on this side, we don't care about ordinary people at all. Oh, imagine that. She said that we have no business about the people. What we're interested in is the few selected people that we might know personally and so on. A kind of cartel, as they are being accused now of being aligned with over on the other side. But we always cared about the people, and I want to raise two issues. And these two issues have to do with constituents who have come to see me. One issue has to do with a man owning a piece of land. A person coming on the land and establishing that he is the owner of part of the land. So let's say the person has about 10 acres of land. And this person comes because the owner is absentee. And he builds a house on the edge of the land, but he takes about 2 lots of land from the person. And because the fellow has 10 acres, you see, he builds it on about, and he proceeds to fence the land and so on. So the owner goes to him and says, but you built your house on my land. Well, the fella argues, they want to fight and so on. The fella goes, he brings the deed, he brings the surveyor, and he realizes now that he has built on somebody else's property. The fella, instead of dealing with the situation there because the landowner was being reasonable, let's come to some understanding. You know, if you want to sell your property, I will buy it. If you want the property, pay me for the land. You made a reasonable choice. Gave him a reasonable choice. The fellow proceeds to sell the land to somebody else. Okay?
That's the problem.
So there is now another owner that owns land that does not belong to him. How does this bill and the adjudication process treat with something like that? And I want to say it's a real issue, and I know that the Attorney General is busy speaking now, but I would like in his winding up if he would address this issue. How do you address a situation by the adjudication process if a person were to take ownership of land that is not his, belonging to another person, and then sells that piece of property to another person? Well, all right. Then the second issue I want to deal with is this. I think you know that in Trinidad and Tobago, besides the banking system, the credit unions, the financial system in this country, I think you know that there exists informally in the economy a money lending system. There is no legislation that I'm aware of that covers the issue of money lending, if you're going to be constructive.
Which you never is.
Thank you for giving way. I really wanted to say, since you asked the question to all of us as a legislative place, yes, that in the case that you defined a while ago with someone selling land that he did not own, that's a clear case of criminality. A report to the police, the fraud squad, will treat with that as it has been done many times in our history. Yes.
All right. And there is a money lending system that exists in this country, and you have money lenders. Unlike money lenders anywhere, money lenders in Trinidad and Tobago tend to have strong arm support in order to make sure that monies that they lend are in fact returned, okay? So that a money lender does not want a default loan, and the interests are generally high. I have a situation in which a citizen from my constituency comes into my office and he tells me, look, sir, here's my problem. My son owned this piece of land on which I built a house and I've been living for the last 30 years. My son went to a moneylender and he borrowed X amount of dollars and released the deed in the hands of the moneylender for the sum owed. The moneylender has now come to me and has told me that I must leave my house because the land now belongs to him. And although I have lived here for the last 30 years, my house isn't finished yet, but I have lived in it and keep making it better, etc. I am in fear because I don't know what is going to happen to my situation. He said, I do not have money to pay back the loan. My son is now dead. The person died in the process. And I have a situation that I must deal with, and really my life is threatened in all of this. I must say I was at my wit's end. I told him, I said, you have to go to a lawyer. I say, because as your parliamentary representative, I can't really help you. But in this system that we are establishing here, how does the system take into account something like that? Because I suspect that in the money lending process, there would have been lawyers involved, there would have been things signed, there would have to be a distinction between the ownership of land and the ownership of the house. And I would think that the whole purpose of law in a civilized society is the dispensation of justice. And therefore, I want the
Honorable Member, you have 2 minutes of your initial 30 minutes.
Yes.
Because we'll be suspending at 5, so proceed.
Okay. I want to ask the Attorney General if in his winding up he can address, I know the member for Laventille West has said one is a criminal matter that should be addressed to the police. I don't know if you're going to get police action on that. And the second one that I raise, I wonder if it raises some complexities that the law, such as we have it, and the adjudication process does not, in fact, address. So I raise these two issues, Mr. Deputy Speaker, because they are real issues coming from the people, real issues coming from the ordinary experience of ordinary people in the business of land. And I have about 5 or 6 issues that have come to my attention over the last 2 years in my own constituency having to do with family disputes, neighbor disputes, etc. One of them erupting into violence because of the nature of the engagement, I guess, of the neighbors involved and so on. And these are very, very important issues that need to be addressed in terms of the law, because if the law does not cover the reality of cultural experience in Trinidad and Tobago, and the Attorney General actually used the word culture in this process, he basically said that they had made adjustments or amendments to the law, which basically was a culturalization of the law to take into account Trinidad and Tobago reality and experience. And I would like the AG to address those particular issues. Mr. Deputy Speaker, if you'd like, I'd stop at this point, so you take the break, and I'll come back and speak for a few more minutes.
Okay, honorable members, we'll now suspend for tea, as agreed by both sides of the House, and we'll resume at 5:30.